हे भगवान।
Notice City Milord. The paperwork has already been prepared. Paperwork has already been served upon the Union of India.
All inclusions, please give.
My lord, under
Inclusions
compelling
you give.
circumstances.
First, all inclusions you give.
Good.
Anybody seeking inclusion in the list, you give. Please give. Give. Restoration, we list it on Monday. Extension, when does it lapse?
January.
We can list it on Monday.
My lord, under compelling circumstances.
All inclusions have been
One inclusion, one inclusion, minor, three matter final disposal, this division, this is loco pilot matter. Two are is pending, that two are pending. All is covered by minor.
Can you give the judgment also
Yes.
with the slip? Take it with the slip.
Let
Let us see. Okay, custom. So include in the next monthly list. Next monthly list included. Yes.
My lord, under compelling circumstances, my lord, I am mentioning item number 147 on today's list. Where, my lord, the difficulty is when your lordships are not in session, where in the circuit bench, my lord, your lordships heard this matter on the 3rd of December, my lord. This is a transfer matter relating to transfer, my lord, where I have challenged the order of the Honorable Cat, my lord, before your lordships. Lordships, the matter is pending for consideration before your lordships, my lord.
It is pending before the cat.
No, Cat passed an order. It's a subject matter relating to transfer of my client, my lord.
147.
147, she is a senior auditor, my lord, and her spouse is also stationed in the same place, my lord. And she is entitled to that rule, my lord. And even administrative requirement will not work. That is a DOPT circular. But, my lord, taking advantage of the fact that the matter was pending before your lordships and your lordships were in circuit, my lord, the respondents have relieved her, my lord, in spite of direction of Cat not to relieve her before passing of the speaking order, my lord. So today, my lord,
It is a fait accompli. If it will come in the next monthly list.
no, my lord, it is appearing in the list, my lord. Today, I want the matter to be taken, 147, my lord.
No upgradation. You wait. Yes.
Lord, I was also
Serial number 158.
Yes.
All India, the matter has also been settled by the High Court, several High Courts have happened by Supreme Court.
Come with consent. Come with consent. We'll take it.
612, my lord, I have already said.
Come with consent. If it is agreed that it is to be disposed of, then otherwise it will come out.
File an affidavit, they have filed an affidavit, they have admitted.
Then it
That
will
will
come
be
on its own. It will come on its
Immediate, my
own.
lord,
Yes.
for application.
Next,
Matter will be
anybody
taken.
else?
item number 233. Now, this matter relates to the police who were ex-army appointed contractually. We have moved the state administrative tribunal. The state administrative tribunal is of the opinion the single bench cannot hear.
For what?
Formula equal pay for equal work as well as regularization, because we were all appointed against sanction post.
So when it is taken up.
And I was
Yes.
praying for upgradation because
Sorry, yes.
the
There's no
state
case for upgradation. Upgradation means something has to be, some order has to be passed today. That's not the circumstance.
I'm not
Yes.
placing today. Next week.
May be given for the appeal without certified copy. The order passed, yes, but the order passed 20th December. Without making me the party, the interim order passed against me, which I have only come to the knowledge when this
By which forum?
but the single bench, the Justice Rai Chattopadhyay, the group 7. But the group 7 appeal, this your lordship is holding this group 7 appeal, and this is it is the before the trial court I was not made a party. Leave may be given. Well, 20th December, yes, this came to my knowledge, this month, because I was not made a party to the. No, I was not made a party therein.
Get the certified copy.
Your lordship kindly appreciate the leave petition has.
How many times you will say that? We have heard, but then the point is it is already beyond limitation. You get
No,
this
but
certified.
one line. I was not made a party, so I.
So you are not made a party. You have said at least 4 times that we have heard. Get the certified copy.
One aspect,
Yes.
because this is an against an interim order.
Correct.
So, unless I made the party therein, I cannot even get this one a certified copy, making the applications because
You have applied for being.
is pending.
Have you applied for being implemented as a party in that case?
There, your lordship kindly appreciate.
Then you wait. Yes.
See, I have
Anybody else?
applied for. Next, 15th
Yes.
of January, one order has been passed. I have made it. 15th of January. This is that. Kindly.
What is 15th of January?
15th of January, an order passed. I have applied for certified copy. There is some urgency, but the
Come with the certified copy.
Leave may be given. मतलब group 7 matter मतलब
Come with the certified copy.
मतलब kindly appreciate leave may be given मतलब जो
No.
मतलब without certified copy. I have applied for मतलब.
Yes.
I
What
think
is the
minus-
interim, what interim order has been passed?
There.
Yes.
My right has been affected by the order which has been passed against me not to give effect to a resolution issued by the State Transport Authority West Bengal. So where my right, in my
Why you appear in that proceeding? Why are you here? You can appear.
they are
Sorry,
the matter
yes.
will appear after final.
Leave to mention.
Yes.
I think my lord's kind leave to mention this matter. My lord was pleased to reserve this matter for judgment, my lord. Thereafter, while passing the judgment, my lord required some clarification and therefore fixed it to be taken up on 6th of November. My lord, neither it was taken up on 6th of November, nor my lord, it's a
Give the
matter
slip,
which has
we'll
been
see.
fixed for
We'll see.
passing the judgment.
My lord,
Has to come. Get it on the list next week. See if it has not been listed, get it on the list.
Much obligation.
Section one, matter for trading lordship. Lordship, the affidavits that already exchanged lordship and the matter is of 2015 lordship and
15.
2015 matter lordship.
What is the issue?
Lordship, this is like Union of India is not paying our wages lordship. And some of the we are from the respondents, the union has preferred this appeal before your lordships and lordship we
You are not the appellant.
we are the respondents and some.
Any interim order has been passed against you.
No lordship.
Then you wait, yes.
My lord, we have filed a CAN in WPST 415 by 2010 for recalling. It's a recalling application. So I have mentioned it twice earlier in other court, but I have been told that it will come under your lordship's determination.
When did you file the CAN?
It's in May 2024.
You are mentioning in January.
I mentioned in on 29th August 2023, then 23rd December 2024.
Yes, list it in the next week.
I talked to SU also.
Talking to SEO is not required. You
No,
required to mention, yes.
Yes, my lord.
Respondents, some
Next
of the
week.
respondents have died.
Get used.
Grateful, my lord.
But some of the respondents have died.
Ask the appellant to mention. It's not your appeal. Don't mention it. Yes.
My lord, may I be permitted to mention, my lord, this matter, my lord, your lordship is heard extensively. Then, my lord, after change of intersection, the matter went to court number 3. And after hearing us, my lord was kind enough to release the matter. And after that, my lord, on 3rd of January, December, my lord, it is assigned to the lordship.
So it will come inclusion. Next month. All the inclusions in the February.
my lord, your petitioner is senior citizen of India and now 82 years old. Three chance.
You are appearing in person. You are appearing in person.
Yes, in person, my lord.
Yes, take the. We had asked him to mention after. Yes.
So MAT filed by me on
Give.
year of
Give.
28.
Give, please. First
My
week
lord,
of
very
February.
extensive
First
matter.
week.
Now I am old person. May kindly consider this matter
We have taken
and
your slip.
set the matter as soon as possible.
We have taken your slip, sir.
Allow for
Unless they have concentrated by filing affidavit, then they will.
Yes, call the list.
My lord, with leave of Honorable Justice Prashad, I want to mention a matter before Honorable Justice. My lord, it's a second appeal arising out of a eviction proceeding, my lord. My lord, I have a ground of reasonable requirement. My lord, the suit is pending since 2010. My lord, and it's a prime property located in Kamak Street, 2000 square feet. There,
Under which heading it is pending?
it's a second appeal hearing of
Under
second.
which heading it is pending? Is it under part heard?
Ready for hearing, my lord.
Is it under part heard? Has it been heard?
My lord, it's not part hard, not part hard.
When this bench sits singly, you move.
My lord, the only problem is that, my lord, I have some reasonable requirement. My lord, I am housing my staff by taking a separate property, paying exorbitant rent there. My lord,
I will be sitting singly soon, whenever it might be, on Friday or whenever, whichever date. On that day you mention.
my lord,
My lord, much obliged.
What is there?
Much obliged.
Item number 1.
My lord, I appear, my lord, for the respondent on the last occasion.
Yes.
I actually sought for a time
Yes.
to raise certain issues. Now, your lordships have been pleased to hear this matter extensively, but I wanted, Sir Lord, to point out some question and also some judgments.
My lord,
Now,
though,
this is a matter.
but here you lord kindly appreciate me. I am for the petitioner. My lord, that in that regard, my lord, on
Just give us 2 minutes. Just
just a minute. On 14th January, my lord, they have submitted a written note along with that one judgment. What else my learned senior friend will address, my lord?
I shall have to explain. I shall just take 10 minutes, nothing more than that.
we are trying. Just let us see. We must refresh our memory. We can't
Yes,
remember.
Lord. Yes, my lord. My lord.
No money.
What is the cat's judgment dated?
Yes, my lord. It's the judgment dated
30th March 2012.
what I counted. So 35 course.
Yes, 30th March. Yes, you will have to refresh.
Yes, my lord.
You will have to refresh. It's been quite some time. You will have to refresh.
Then my lord, kindly grant me some time, my lord. Because,
Where is the speaking order?
yes,
Where is the speaking order which was passed? Which
my lord, at page 49 of the writ petition. Page 49 of the writ petition.
These issues
Well,
are-
I have got a preliminary question. May I just raise it now?
Yes.
Now, your lordships are aware that when in a judicial proceeding or a quasi-judicial proceeding, an authority has been empowered to pass a reasoned order, and pursuant to that order, a reasoned order is passed. Whether there is any scope for Milord preferring a petition of judicial review, because your lordships are not sitting in appeal.
No.
Number one.
This,
Number two is,
this
number
reason-
two is,
Yes.
number two is, Milord, the Supreme Court has said the limitation of power of such judicial review when a reasoned order is passed, and against that, Milord, this judicial review is sought for. Now, in the second round of litigation, the Central Administrative Tribunal rejected the claim of the petitioners, and against that they have come before your lordships. Now I shall be placing only two judgments of the Supreme Court. But my Lane Junior is there, he will hand over. If your lordship kindly allows me to take that preliminary question.
No, you may take that preliminary question, provided, what is the fact, this order of 22/12/2008, which has been passed by the general manager, It was subject matter of the proceedings in the CAT.
The subject matter of proceeding in the CAT was whether the petitioners are entitled to both SCP benefits and promotion simultaneously and fixation of pay scale. Now
No,
here, Milord,
perhaps not. That was the subject matter in the first round of litigation. Thereafter, the matter was decided by the general manager. Now, the general manager's order was assailed in the CAT, or some other order was pending in
Yes,
the.
no. That was
Yes.
Milord, the general manager's order was assailed in the CAT.
Yes. So, therefore,
And the CAT rejected it again on the
correct.
ground. And secondly, the regent order which has been passed, it has stayed the recovery proceeding.
That is
So
why
therefore,
we were just going to go through it. In the meantime, you made this objection. So, what is the after the reason order? What is the effect? Only the
Yes.
recovery aspect has been stayed,
yes,
but the fixation has been done on the lower scale,
yes.
or they
No,
have.
the issue is whether the petitioners are entitled to both SCP benefits and promotion. Both. And in such a case, if by a mistake SCP benefit has been granted and thereafter a promotion has been granted, whether the authorities are entitled to recover. But recovery proceeding has been stayed by the order of the general manager. Now, preliminary question I am raising, Milord, before your lordships, that whether after the assignment of the power to the statutory authority or the general manager and the reasoned order is passed, whether there is any scope for judicial review because your lordships are not sitting in appeal.
No. But that is not a fact. That has to be a fact. Then only you can place that law. It is not a fact that after the disposal of the matter, the reasoned order has been passed and we cannot see it. After the reasoned order has been passed, the CAT has examined the issue, and that is before.
Yes, that is before your lordship.
It is not a fact that after the CAT, the reasoned order has been passed and therefore we cannot sit in review.
Do not kindly appreciate 77 Supreme Court page 5.
Yes.
Question of law can be raised at any stage of the proceeding.
No, so the matter was it was remanded to the authority by the CAT. Thereafter, the authority's order was subject matter of the issue before the CAT. So now it is before us. You are saying that once it has been relegated to the respondent, then for a reasoned order, then we should not sit in judicial review. But that's not the fact. The fact is that that order was already subject matter of challenge before the CAT, and that matter is before us. It is not a case.
Milord, but the CAT has affirmed the reasoned order.
That is all right. So we have to see that the objection you are raising appears to be on a different set of facts. It is not a case where the CAT has relegated the person to the authority and the authority has passed a reasoned order, and then therefore we should not sit in review. Then of course they would be required to approach the CAT again. They have already done that.
Yes.
So therefore this objection is based on a set of facts which are not occurring in the present case. It's not a case where after the CAT they have been relegated. With judgment, what are the facts? Let us see.
But may I make
Doesn't
one
appear to
submission?
be. Just a minute. Let us see.
Let my learned place, my lord, before that one submission I am making. The very self-same issue, my lord, was tested before my lord, Central Administrative Tribunal bench, Punjab and Chandigarh bench. That they are against.
We are yet to ascertain what is the issue and you are all making submissions. We just opened the reasoned order. We are trying to read. Let us understand what is the issue. Then you make your submission. He has made his preliminary objection. Yes.
Lord, may I place the reasoned order?
Yes, we are going through it. Just
judgment এখানে এটি দেখাতে হয়।
The reasoned order has been passed by the Director of Accounts, Postal Kolkata, not by the General Manager. That has been mentioned in the office of the General Manager.
Office of the General Manager, yes.
Yes. Now the reasoned order actually concludes by saying from page 52 onwards, sorry, is from 51 onwards, If your lordship kindly allow me to place what is the result order. My lord, I should better bring your lordship's attention to page 50, last paragraph, page 50, last paragraph.
No, first of all, these petitioners are postal assistant.
Yes. As per the directives of the ACP and subsequent clarification, it was evident that either their entry grade pay scale was the same or it was one stage lower than what they were having now. Thus, the cases of these officials were first referred to DT, PA wing, VDA, this office letter number, such and such, dated such and such. But the PA wing in turn informed this office, VDA letter number such and such, that any point of doubt may first have to be referred to head of the circle for clarification. The matter was then referred to the circle office, VDA such and such, as per circle office clarification communicated VDA letter number such and such. Joint accounts applicants who had come under Rule 38 from the various fields units of West Bengal Postal Circle were awarded the financial upgradation under ACP scheme in the scale of rupees such and such from such and such. VDA office order number such and such, which was extended notionally from rupees such and such with effect from 1st January 1996, with actual payments being made from 19th February 2023, VDA directors PA number such and such. But this is the conclusion, my lord. But the DT VDA letter number such and such communicated the upward revision of pay scales of accounts employees. As per this order, the pay scale assigned to the junior accounts cadre number such and such, thus the basis of which the financial upgradation of all these applicants was granted, stands no longer valid. After the receipt of clarification from the Department of Personnel and Training with a letter number such and such, and as per Ministry of Personnel, Public Grievance and Pensions, dated such and such, wherein it has clearly been stated that cases where the ACP scheme has already been implemented shall be reviewed, rectified. If the same are not found to be in accordance with the scheme or clarification, accordingly their case was reviewed and regulated with an order number such and such, but the recovery of overpaid amount was ordered to be kept in abeyance until further orders. In this regard, the decision of Supreme Court in Comptroller and Auditor General of India and others versus such and such, and Bangalore bench order dated such and such, may also be considered. According to this analogy, the officials who had been transferred to this PAO, Kolkata, under Rule 38 of the PA&T manual, is our own request and absorbed in the lowest division clerk cadre in the pay scale of such and such, he may require to forego any benefit of the post which he say was holding previously. Therefore, though the pay scale of sorting assistant and that of accountants of this PAO placed at par with such and such, recommendation of CPC, the applicants will never get the benefit of this as he has opted the transfer on Rule 38 of the Post and Telegraph Manual. Now, this Rule 38 transfer scheme is application on the basis of their own volition, they have sought the transfer. So whether they can approve it and reprove it now, or whether, my lord, these clarifications, notifications are challenged before the CAT, that is also an issue.
Where is that Rule 38?
My lord, Rule 38 issue long ago settled by the Supreme Court.
Where is it, sir?
But it is there, my lord. I had handed over. I thought, my lord, that since it is 4 orders, my lord, I'll place. But this issue, that whether on only.
Therefore, we are.
But I have given, my lord, in the bunch of judgment and my lord, that they are, my lord, the manual is there.
You will have to refresh. Can't be done.
Yes. I shall, my lord, then, my lord, kindly grant me some time so that I can come with a short note even. Pointing out that, my lord, that the issue of Rule 38, whether this benefit will be available or not, Supreme Court has long ago decided, and my learned senior friend possibly knows it.
So you exchange that, you give it to the.
He is saying, I shall again place, my lord. I shall again place. Not only that, the judgment which has been referred to here in page 52 of the order of the appellate authority, that is, my lord, the audit comptroller and auditor general of India and others versus Farid Sattar, it's on completely on a different precinct.
We will see.
Number two. Number three, my lord, this Bangalore bench does not hold good anymore in view of subsequent decision by the Chandigarh bench, affirmed by the Punjab and Haryana High Court, and the SLP dismissed by the Honorable Supreme Court.
Then we will kindly keep it next week. We shall come with written notes.
इधर वाला नहीं चला.
But this argument possibly doesn't lie anymore.
No, whether this will lie or not, that your lordships will decide.
It's my submission. It's my submission.
Question is whether, my lord, on an application on their own volition, they have sought a transfer and their pay was fixed, whether they can be doubly benefited both by ACP and promotion and fixation. Therefore, kindly place it next week. We shall file a written argument. Your lordships have been pleased to hear.
Already given by the
Next week is all right with you.
But a little more time if could be granted, because today when I have just missed another appeal, all these come together, my lords. If some more time can be granted.
Very well. I have no objection.
Why don't you give us an agreed date so that day there is no.
Next Tuesday.
Next Tuesday is 28th January. He's saying next week he has some problem. We can keep it on 10th February because
10th February.
yes, it's a Monday.
Yes, my lord, yes. My lord, only, my lord, instead of 10th, it would be lordship's pleasure to place it on 11th, because
Not
10th is
yes,
10th is a day of residuary bench matters before the court number 1.
Very well. 11th. Jointly
well.
prayed for further submissions. The matter is listed on 11th.
বাড়ির বই তো দরকার আমার কাছে আছে। বদমাইশ কোথাকার শুধু হয়রানি করছে সমাজে। আমাকে আজকে কফি বলতে পারি।
Item number 2.
Lordship, in item number 2, in item number 2, 4, 5, 6, and 7, I'm appearing. My lord, I could not remain present in the court today because of my certain health issues. My lord, I pray the matters may be fixed on Friday of this week. Means day after tomorrow.
Any other given beyond Friday, right?
Already in item number 5, I am for the respondent.
Well, my lord, in item number 5, my submission is that the petitioner has already been granted compassionate appointment for which the petition was filed.
So that can be disposed of.
It has been informed to me
Once
by
that
the petitioner.
So there is no dispute on this aspect.
Yes.
In item
On item number 5 only, my lord.
that we have heard, sir.
Yes, my lord.
Is the parties are
Respondent.
respondent.
Yes.
5. Respondent is Union of India.
5. Union, under
5.
respondent. Yes.
Yes, my lord. The respondent is Union of
We are
India.
for the respondent.
Sir, you are for the petitioner or respondent? You don't even.
Respondents.
My lord, I am for all the petitioners.
He is for the petitioner.
From item number 2, 4, 5, 6, and 7.
5. Give the file of 5.
Hearing for the respondent in 6 and 7.
Give the file of 5.
I don't legal. Item number 5. Banerjee na.
All right, first we'll 4. 4 we are fixing on Monday. As played by the parties jointly.
My lord, item number 2, 4, 5, 4, 6, and 7.
2. First we are taking up 2, yes.
Served
We
by
are fixing
advocate
on Monday.
Above.
As played by the part jointly played by the
Already
parties
covered.
based on
One
the
number,
date of Monday.
Procedural.
And 4.
My lord, could it be could it be fixed on Friday? Please,
You
my lord.
already prayed for Friday. Friday he has difficulty. We are fixing it on Monday. We can't ask you a date every time before we fix a matter. Sometimes you also have to come to the court.
My lord, I could not come to the court because of my health issues today.
You
Suddenly,
should have addressed us virtually. Why do you want on Friday? You are there virtually. You address us today.
apology, your lordship.
You can proceed. We are willing to hear you. More than willing. You don't want, then we are fixing it on Monday. You appear virtually, physically, whatever you want to do. Who is in 4?
My lord, I'm in 6 and 7.
In 4, you are for the respondent.
I'm for the petitioners in all these matters.
So, as paid by the Learned Council for the petitioners, list on Monday. Give the date of Monday.
Yes.
Please be that side, sir.
My lord.
Please be that side. There is a reason why we are in confusion. Yes. The parties are ad idem on the issue that
Seven, I am appearing for the respondent.
6 is also a part of this group.
Yes, your lordship.
6 and 7, you are for the Union of India. Monday, all these remaining matters on Monday. Yes.
I'm grateful, your lordship.
Monday. Great. Right.
Only 5 is
5.
Item number 3.
My lord, item number 3, my lord. I am mentioning on behalf of Mr. Harazan Banerjee. He was admitted in the Apollo Hospital, and day before yesterday he was released. And my lord, doctor advised him to take at least 10 days or 2 weeks time, my lord.
So what do you want?
He was suddenly attacked with pneumonia, my lord.
What
In this matter, I am appearing for respondent number 6.
My lord, I am praying 3 weeks time, my lord. Deeply obliged.
the Learned Council, Mr.
In this matter, I am
আমার সঙ্গে তো এটা হাতে রাখ হয়ে যাবে
Item number 8.
Yes, madam. This is my application. Affidavit service. Affidavit service. Well, this is a application completion data. একটা দিয়েছি ওদের, আর একটা নেই। আরে, ভুলে গেছি, একটা দিয়ে দেবো আমি জিজ্ঞেস করি। দুটো পাঠানি কেন? My lord, only one copy, my lord, affidavit service I am filing, my lord. Another copy I will hand over, my lord.
Give it today.
Today, yes.
What is 10BB? 10BB has been referred to of notification 26 EMP. Come this side. Come in.
Notification EMP allows text.
NB, my lord, notification. Their notification, they have to apply within 2 months, 2 years. So my father, my lord, and secondly, my lord, within 2 years, date of day, within 2 weeks, 2 years, have to apply.
No, apply. See, you have applied within 2 years, but then pro forma application was to be submitted.
Yes.
So
My lord, my lord,
And it was filed
within 6 months from which date?
from the
date of death.
date of death.
So my lord, what happened?
He was within about 32 years.
No,
Maybe.
how it can be? That is why we want to see the provision. It says The application should have been preferred before the respondent office within 2 years from the date of death.
Date,
That is after
yes.
subsequent notice.
That is after.
Subsequent notice.
So that was not applicable to him.
Because he died in 2010.
That 24/4
That we have seen. Don't worry. We are clear on the dates.
is my case, my lord. Let me
Yes.
finish.
Yes.
Yes. My lord, my mother's, my lord, my father was a Gwala under the Department of
24/4 he died. Your mother made
24/4
an application. Your mother made an application for you on 14/6.
Yes.
So it was within 2 months that she has made the application.
32. Page 32, he applied on within time. Yes.
That is, please. So there is no dispute on that.
That.
After that, they say pro forma application was submitted late.
Right.
So is there any provision which requires a pro forma application to be submitted after an application? Under which provision that time is specified for
And
pro
one
forma?
thing, my lord, also my lord said, my lord, the dispute, my lord, the mother not applied that receipt not eligible. Your lordship kindly said, it is not the understood last order of the last. It is not understood why being eligible at the time of the application did not feel necessary to apply for such employment when the stipulated time. My lord, I applied, my lord, in time, my lord. It is legible, but my lord, it is their receipt, my lord. Last 3 lines up. Last up after 3 lines, my lord.
At the time of day.
Just. This is of the time which was existing in the notification of 2/4/2008. That has been made instead of 6 months, it has been made 2 years on 1 March 2016. So they say in the present case, this 24 should have been after 2 years from the date. Even if either of the notification is applied, it will be after 2 years. But he says it has been made in June 2008 itself. That will be June, then it may be accepted. So where is the application your mother made in June 2000?
Yes, my lord. This is not the original receipt.
Where is it in the app?
Page, my lord, 25. Mother, not 20, 32.
32.
30.
32.
ঠিক বলেছি।
32 to the points of law.
No, he is correct. Annexure E.
Yes.
There is a handwritten 32 in the center of the page.
This is my lord, mother made an application on 14/6/2010. (32).
So it is your case that this is why you are not relying on this application.
In time, my lord,
why you are not relying upon this application?
কথাটা অন্য জায়গায় আছে। লাইনটা অন্য জায়গায় আছে।
বাক্যটা কোথায়?
But I wanted to see 26 EMP.
No, we are, that is all right. We are asking you why you are not relying upon this application of 14/6/2010. Why you are ignoring this application of 14/6/2010?
But I see that date of application is 14 to 2010.
14/6.
14/6/2010. But it must be filed within 6 months.
It is within 6 months.
No, but it was filed
14/6.
6 months, 4 days from the date of death.
No, sir. The date of death is of April 2010. An application has been made in June 2010. So it is hardly 2 months, some days.
But pro forma application was filed on 28 December 2012.
That's not the point. Where have
That is the very. But our application must be in the prescribed format. If that prescribed format application is not, that would be entertained.
that will not be treated as an application.
But the provision is there.
My lord, Supreme Court judgment, I have annexed, my lord.
So that is you are not denying this 14/6/2010 application,
Application cannot entertain the
but you are saying it could not be entertained because it was not submitted on the pro forma.
He could not,
Let us see the rule requiring pro forma.
pro forma. Pro forma, that is the last week can see page
page 33.
33. Page 33. Because everything has to be disclosed there. Date of appointment, date of birth, date of retirement, and income, basic pay, everything will be there.
So this has been submitted in 2012.
Yeah.
Let us see the rule, the provision under which this pro forma is to be submitted.
Yeah. Thank you.
My lord, they appointed three-man committee. Three-man committee recommended my case. Their appointment.
Now, kindly see paragraph 4 of the resolution of 2008.
2008.
Paragraph 4. Subject to correction, my lord.
I think we have it.
That is notification number 32 EMP. It's for 30 EMP. EMP means employment. Dependent upon the family seeking an appointment on compulsion ground shall henceforth make an application in the prescribed pro forma within 6 months from the date of the death of the deceased employee or in retirement or permanent dismissal. If no application is submitted within stipulated period, it will be presumed that family does not require immediate financial assistance. That is language of 4 of the.
That is what is the EMP number?
EMP number 30. Most probably page 39.
Supreme Court judgment আছে।
I will not say got it.
Yeah, what is it? Page 39. Yes.
I will not say got it.
Yes.
Now kindly see page 41, paragraph 4.
And where is the earlier rejection? Where is the earlier rejection? Which was subject matter of OA 690 of 2022.
Earlier rejection. আগে যে রিজেকশন করেছে সেটার কথা ছিল আর একটা
Kindly see page 79.
Seven.
80A.
Page.
And the page 80 capital A. 14 June 20.
No, earlier rejection by the authority.
Earlier rejection by
the authority.
Oh.
Another page 78.
Eight.
17.
88.
Not take this down. He died in 2010. The application will be considered.
No, whether res judicata principle to be applied.
res judicata किससे था? कोटी जाके चला था ये अनरिपोर्टेड My lord, Mr. Mukherjee raised the question, my lord, that pro forma application was not made in time. Well, on that point, my lord, our division bench judgment, my lord, page 86, unreported judgment, and also that judgment also affirmed by the Supreme Court, page 86, my lord. 86, kindly see the order of the division bench.
Page.
কি বললো? Oh, yes, my lord. Three-man committee recommended my case, my lord. Page 40. Page 40, my lord. This family is under starvation. Page 40.
But rule says that ultimately to be decided by the government and the cabinet.
Well, last line, my lord. Pension for the first month of the disbursement, so and so amount, date of date, so amount that, and 5% annual, and calculated the monthly basis, other amounting 11,660 and amount, which is below 90% of the salary by Kalipodo Sardar. We recommended proposal for appointment on compensated ground. They appointed, my lord, three-man committee. Three-man committee, my lord, submit the report.
No, under the
And where is the decision of the departmental committee?
This is department, they appointed.
No. Under the statute, there must be a three-man's committee. Committee has to be considered.
Recommended.
Then it will go to the government.
Then it will go to the departmental committee.
Department.
Yes.
Government. It will go to the government.
No, sir. Please see your page 78, 4 subclause 3. Now taking into consideration the report of the three-man committee.
Yeah.
And whereas the departmental committee on examination of the documents. So what the departmental committee examined? Where is that departmental committee's examination? What condition did it find that he does not fulfill? It says the departmental committee found that the present application for appointment cannot be granted. It does not fulfill the requisite conditions laid down.
Yeah.
So where is that? What condition it did not fulfill? Where is that? Departmental committees.
It has not been annexed. I don't find any in a document.
No, that is your document. That is your document.
No, sir, certainly.
That is a reference made by you to your own document.
Yes. Then I should have to bring that.
And you are relying on which judgment?
My lord.
Judgment.
You are relying on.
My lord, judgment, my lord, 86, my lord, our division being judgment, my lord. When the petitioner could not make the 86 page, well, this is division being judgment. My lord, the last page, page 90 order. The respondent authority, instead of rejecting the pair of the last page on the aforesaid grounds, should have asked the members of the deceased family to submit an application pro forma. And this order also division, they paper appeal before the division, Honorable Supreme Court. Supreme Court affirmed this order.
That was prior to 2008 EMP. 2008 EMP has imposed the time 4 years after that. So this case will not be a precedent. Your case, the facts are different. There, the application was made in 2004, much before. So what is the? Let us see what if.
This is the division bench judgment, identical ground. The division bench said when the petitioner could not file the pro forma application, petitioner or petitioner mother should inform or rejecting the. That was not done by the.
That application was made in 2004. What was the rule governing the consideration in 2004? What was the notification?
Notification not with me, my lord.
When you are relying on a case, you must assist the court with everything.
My lord, page 891.
What is that page 91?
That is the, that is my lord,
In 2004, was there any MP saying that it has to be made on pro forma?
that is my lord, I have
Then
no
why
idea.
are you relying on the judgment which is different on facts? Which does
No,
not
that, my lord, that time, my lord, the petitioner could not file the pro forma application in a CAD matter, Central Administrative Tribunal. That the Central Administrative Tribunal rejected the application.
don't know what is the rule there. We cannot rely on a judgment like this. This will be a law only in respect of the rule which it is considered. Here in clause 4, they specifically say that if you don't make it, it will be deemed that you don't require the appointment. So therefore, we are trying to see, earlier departmental committee has said you do not fulfill the condition. So have they changed the ground now? Earlier, they could have said we are not considering because it is not in time, but they have not said that. So where is that departmental committee's order?
Nothing has been annexed.
We have heard the learned
Page 69 দেখুন আপনার স্যার।
Item number 9.
Item number time for the service. And I'm filing the affidavit, sir. But I was a deliberated worker, working in the district magistrate office.
You are a
Deliberated worker, working in the district magistrate's office. Now my services were terminated after I had approached the administrative tribunal seeking benefits of a certain memo which guarantees 10 years service up to the age of 60 years. Now, my lord, I had approached the tribunal initially at page 61. If your lordship will kindly takes up page 61. And this is the first round of litigation before the tribunal. My lord, by 61. My lord, may I place the second paragraph at page 61? And the first paragraph quotes the memorandums. None appears on behalf of the respondent on call. The contention of the applicant is that he has been working as a deliberated casual employee in the establishment of district magistrate and collector, Birbhum, for a considerable period of time, but he has been deprived of financial benefits in terms of the memorandum issued from time to time by the Finance Department, Audit Branch, Government of West Bengal. On consideration of the fact that the applicant was paid remuneration from the Office of District Magistrate, we are of the view that the issue whether applicant is entitled to get the benefit as paid for should be decided by the district magistrate and collector, Birbhum. On the next page, accordingly, the respondent number 2, district magistrate and collector.
What is the reasoned order?
On the reasoned order, lordship will find at page 69. Page 69. 63 actually no, sir. 69 actually. 69. That kindly takes up towards the bottom of page 69. The applicant appears for hearing today, the 15th day of February 2019, and filed Hazira. Heard the applicant, he claimed that he has been working as a deliberated worker at Birbhum Collectorate since 2008, initially for more than 240 days a year till the year 2013, and later on for the less than 240 days a year till 31st of August 2018. As such, he claimed that he should have been given the benefit of consolidated remuneration in terms of geo number such and such. However, no corroborative document was submitted by the applicant to substantiate his claim during the course of hearing. After hearing the applicant and going through the relevant official documents, records and geos produced by the DOMA and CSC Birbhum, following facts are established. Next page. That the government of West Bengal, in terms of geo numbers such and such dated 16th of September 2011, allowed benefits of consolidated remuneration of rupees 6,600 per month and other benefits to casual deliberated workers who were engaged at any establishment of government departments, directorate, regional office, and other organization or on or before 1/4/2010 against sanctioned post of Group D and rendered 10 years of continuous service at the said government department, directorate, regional office, other organization with at least 240 days of each of service each year. The said remuneration was enhanced subsequently by memo number such and such of the Finance Department. The finding is in the next paragraph. The applicant does not come under the purview of the aforesaid geos, as he was neither engaged in a sanctioned post of Group D nor did he render 10 years of continuous service within with at least 240 days of service each year since his engagement with effect from 10 February 2009. The applicant was engaged on no work, no pay basis till 31st of August 2018 at the Minority Affairs and Madrasa Education section of this office. Thereafter, he was discharged as his services were no longer required. Now, this is I demonstrated before the Honorable Tribunal. This is the findings are factually wrong because I was in service since 2003. Even if I assume that I was since 2008, I am still entitled to benefits of the memorandum discussed. And I'll just place the pleadings before the tribunal and then I'll come to the memorandum. Lordship will find the pleadings at page 21.
Where is your application
I'm placing that.
forming the basis of the reasoned order, based on which the reasoned order was passed?
That was not in the records of the tribunal. Even I did not get it because this was a change brief, but I did not get it.
You have claimed for 2008. How can they consider from 2003 when your claim is from
But I have
2008?
documents to show that I was from 2003.
When you claim a particular relief, it is only that which can be considered.
Lordship. But in the original application, I have described that
That will not render the reasoned order bad. If the reasoned order has to be passed on the relief that you were claiming from the authorities.
Yes.
So if that was a relief claimed from the authorities, then only it can be bad.
If
Because
your
you produce some documents. Today you may produce a document that you are working from 99. Will that render any infirmity in your decision? The decision is to be taken on the facts before the forum. Not before the appellate forum.
If your lordships takes up, my lord,
Where is your first claim made before the authorities?
if your lordships takes up
It
page
appears
20,
to be your consistent claim that from 2008 to 13 you have worked. Thereafter, you have not worked for 240 days in a year.
in the the original application, I have claimed that I have worked
Again, we are not going to look into it that way, please. You must understand your limitation. This is an order passed in 2019. And this is based on the application which you have made. You have appeared in the before the authority which has decided the issue. And it is your specific claim that initially you worked for 240 days from 2008 and from 2013 you are not working for 240 days. Therefore, where is the question of the tribunal looking into any further?
the tribunal has considered this issue, my lord. If your lordships takes up page 54, the representation is there, but it is in
Where
Bengal
is the representation?
at page 54. The representation was actually for enhancing the remuneration in terms of the memorandum.
Yes.
While it's probably it's not legible.
Don't give translated.
It's not also legible.
No, it is legible.
Very difficult to read.
It's working since which day?
Your lordship kindly takes up page page 21 of my writ petition. And this is part of the pleadings before the tribunal, which was considered by the tribunal. If your lordships for once kindly takes up page 36, my lord, I have a certificate from the authorities concerned that I have been working since 2003. And I have produced that certificate before the authorities. And, But my alternate case was that even if it is assumed that I am working from 2008, still then I am entitled to the benefits of the memoranda. And I want to place the pleadings which was undisputed before the tribunal, and then I'll take your lordship to the order impugned.
Tribunal's pleading means nothing. Tribunal is considering a decision by the authorities
Yes.
made on a claim made by you before the
That
authorities.
I had dispute.
Therefore,
I had
what you had claimed before the authority is relevant. You
That
cannot
I had
keep on improving your case at every stage
that I had
and thereby submit that the order passed by the authority which is under challenge is not correct.
that
That cannot be.
I had disputed that this is a wrong recording of facts in the order.
May say anything, we want to see what you said before the authority. From what we have, you seem to have said you have joined in 2009. Forget about 3. Come to page 54. It's in your handwriting.
In 2009, I had joined in the Nazira section. That is recorded in the order also. Before that, I was working in the DM's office. That is my specific case.
You are saying page 26 of the writ petition.
36. This is a certificate issued by the Deputy Collector of Birbhum, which has not been disputed by the state.
Page 36.
Page 36. This is what I had relied on, and
how can you?
This has not been
Work
disputed
no
by
pay
the state.
basis. What does this mean? What kind of a certificate is this?
That is the memorandum also. That even if I am working on no work no pay basis, I am entitled to remain in service until 60 years. I will place the memorandum now.
What does this mean?
He has been he has been engaged as a deliberated worker on no work no pay basis since at least 5 years. As and when necessary, he is a young and energetic. That is my case that I have been working since
What is
2000.
the date of this?
This is dated of this is of the month of July 2008. I have pleaded it in page 21.
You don't find any, we can't see how you are saying it is 2008.
Be that as it may I place the memorandum that my case would be.
No, you show us. You are required to satisfy the court about your claim. We are trying, we are giving you opportunity to satisfy. Don't take us to things which are not relevant. Show us from any relevant record that prior to 2008 you were working. This is unreliable.
This is the only document.
Not reliable. Cannot be. Does not even bear a date.
It can kindly takes up the memorandum once. Even if I assume that it is from 2008, then also I am entitled to the benefits.
If you if you confine to that, then we'll see what is it. You can't claim a prior date there. That's not your claim anywhere recorded before the authority or before the earlier decision also.
And kindly takes up page 55. That is the memorandum in question.
Has to be against a sanctioned post.
That is specifically held by our division bench that in case of deliberated worker, question of sanction post doesn't arise, which has been affirmed by the Supreme Court. And I'll come to that. In case of contractual, post sanction is required, but in case of deliberated worker, there is no question.
Which provision?
Kindly takes up page 55. This is the starting of the memorandum. And I'll place clauses at page 56, clause 5. And this is really in the nature of a continuous. Those casual deliberated contractual workers who will complete 10 years service on 1st July everywhere will come under the purview of this order, provided no such worker, if engaged after 1/4/2010, will come under the purview of this order. This is one clause I'll rely on. The second clause is clause 8. A casual deliberated worker who is engaged in 2 different government department but has rendered services for 10 years without a break will come under the purview of this order. When the tribunal relied on clause 10, this is what your lordship was also. The provision of this order will not be applicable where contractual engagement has been made without any sanction post and for any specific project for a very temporary period after a maximum of 6 years of finishing up the project, whichever is earlier. Thus, in such cases, steps will not be required to be initiated for filling up the post to regular appointment as per recruitment rules, since posts are temporary by nature. And tribunal has relied on clause 10 to reject my claim that I was not appointed against any sanctioned post. That is why I am not entitled to the benefits of.
It has not. It has said that because you did not complete 10 years
That-
continuous.
Then in that case, my lord, I'll rely on clause 5, which says that, my lord, even if I have not completed 10 years, I have to be given the chance to come under the purview of this order. That kindly sees, my lord, the order was passed by the tribunal.
What do you mean be given a chance to come within the
That
purview of this?
kindly sees, my lord, the order was passed.
You are seeking benefit of clause 5.
5 as well as 8.
Please clarify to us, what does it mean?
My lord, it means that whosoever has not yet completed or in the verge of completion of that 10 years, that they are also entitled to remain. Like in the facts of the case, kindly sees there was an order of the tribunal which directed, my lord, the authorities to consider my claim. Instead of considering the claim, they immediately, my lord, dismissed me from service. I was on the verge of completion of 10 years.
Read clause 5.
Now, those casual deliberated contractual workers who will complete 10 years service on 1st July every year will come under the purview of this order, provided no such worker, if engaged after 1/4/2010, will come under the purview of this order. Now, in any event,
Where does it say that your opportunity
well,
has to be
in
given
any
to
event, I do not
complete this period? Where
that-
are you reading that?
well, suppose, for example, I was engaged in 2008.
Yes.
Well,
Where does it say that you have to be given an opportunity to complete that?
well, my case before the
You are saying
tribunal.
clause 5, you are reading something else and you are submitting
Well,
something
my
else.
case before the tribunal was there was a direction by the tribunal to consider that whether, my
Make
lord,
a submission based on the documents. Just making submissions in here, that will not help your
my lord,
case.
this was the case, my lord, before the tribunal.
What tribunal? There is no such provision that you must be given an opportunity to complete
Well,
and acquire.
What
that
I
10
what
years
I'm
it cannot be.
what I'm trying to develop before your lordship is that, my lord, there was an unchallenged order of the tribunal which directed the respondents to consider my claim under this memo.
They have considered.
While considering, when I was in the verge of, my lord, the completion of the 10 years, they have rejected my claim. But apart from that, my lord, the certificate from the Nazira
I have not been in service admittedly after 2019.
yes, from 2000, at least from the
Admittedly.
my lord,
There's no dispute.
my lord, kindly takes up the order impugned before the tribunal at page 69. Page 69. And the order impugned before the tribunal.
Yeah. Discharged on 31/8/2018.
Yes, if I am working from 2018, on 2018 at least, my lord, I complete 10 years.
2018, in light of the, it is considered that.
Well, even if I consider 2008 to 18, 10 years is still there. And my lord, now kindly takes up, my lord, the order passed by the tribunal. My lord, the certified copy is annexed. My lord, the findings of the tribunal will appear at page 3 and 4. My lord, what primarily weight in my humble understanding of the order of the tribunal is that I had not completed 10 years and the worker was not against the sanction post. My lord, the second point, I have judgments to rely that I need not be appointed against sanction post.
Where is the OA filed by you? Let us see.
And OA is of 2019.
Where is it? Copy.
And
Which
at
page?
Lordship. And OA is that page starts from page, my lord, 20 of 20.
Use 30. Page 50. This is RTI application. Trying to find out. It's going to give a translation. CMD. What have you said in annexure C at page 53?
This is an application under RTI Act seeking records.
What is the record that you want? What is the information that you want?
I asked for the records of my past employment.
From which period to which period?
Lord, the period is also not mentioned.
Two 2003 is first time in the CAT. Before that, nothing to show that you are claiming system.
In any event, that document is not disputed by the state in their
That
reply.
document does not say anything to your benefit. That's what we are trying to see. Does
Lord,
not
I
say
had pleaded that this is of 2005, no denial in the reply.
It does not say from 2003.
And I say
It is issued in 2008.
and it is issued in 2008
Yes, and
So
it says he has been working
for last 5 years.
5 years.
So
no
it should
pay,
be
no
from
work, no work, no pay basis. That means in 2008 you started working for 240 days in a year. That is clear. Prior to that, you are not working 240 days in a year. So therefore, that is not to be considered.
Then in any event, I am working from 2008. The alternate case that I have tried.
So 2008 to 13 and thereafter again nothing.
And then my lord, the reasoned order itself records that I have been discharged in 2018. 10 years is completed.
Reasoned order has to be taken in complete, not one line from here or there.
Lord,
The
that is
reasoned
the,
order says much more.
that
It says from 2013, there is nothing to show that you have worked 240 days in a year and finally discharged in 2000.
2013 onwards, my lord, And we have
After that, it says no work, no pay basis you have been working. That means less than 240 days in a year.
and
Therefore, there is nothing on
Alright,
record to
if
sustain
your
your
lordship takes up page 51,
page.
page 51, my lord, we have enclosed, my lord, the particulars of the bill through which I had received the money. And these are of 2015.
That doesn't help you.
My lord, that is the only thing that a delegated worker will receive as regards his employment.
Cannot improve the case. The facts which are there, that will have to be as it is. There is nothing.
My lord, in fact, my lord, the tribunal also recorded, my lord, the কোথায়? তারপরে টাইপ কপি
No work, no pay basis has been defined anywhere.
that has been dealt with by this our High Court, my lord, in two judgments. One has been affirmed by the Supreme Court. This particular memorandum has been interpreted by the, my lord, the Honorable High Court.
We are asking you again, no work, no pay.
Yes.
Can you show us the meaning of this expression from anywhere? We are not asking you to show us interpretation of the circular or the notification. What we can gather from the order passed by the authorities, no work, no pay means that whenever there is work in that month, some work will be taken, otherwise not taken.
That is the ordinary meaning.
So that means it is not 240 days in a year. That certificate which you are relying upon, that will be an admitted position that you are not working 240 days in a year. Because it says on no work, no pay basis. It does not say 240 days in a year.
The memorandum in question, my lord, covers casual and daily rated. My lord, daily rated is the other form of saying no work, no pay. My lord, you come for work.
No.
My lord,
No, sir. That
no
240
work.
days in a year has not been diluted by any decision.
No, that has not been diluted.
So
That I accept.
therefore,
That is
will stand. We have had the occasion of seeing the judgment that you are relying upon.
Lordship.
We have also passed a similar judgment in one case. But the
240 days has
in a
not
year
been touched.
has not
That I that.
Therefore, that is the only thing we are trying. We are trying to see from anywhere whether we can get this. We are unable to find. Therefore, we are repeatedly asking you.
Now, 240 days, my lord, I have annexed, my lord, the bills that have been raised in my favor. That is up to, my lord, 2015. I have been able to obtain. Those I have annexed.
Therefore, there is no case on facts that you have worked 240 days in a year for 10 days. There is no case on facts. Then, unfortunate as it may be, this will be the fate. What can be done?
In the pleadings also, I have made the specific allegation that I have worked for at least 20 days a month, but there is no denial of that.
That doesn't help you. That may be an admitted, that admission is to your, does it inure to your benefit or it defeats your claim? Working 20 days in a month means no less than 240 days in a month.
20 days will be 240 days
No, it does
per
not,
year.
sir. It cannot be.
12 into 20 is 240 days.
It can't be so arithmetic. Just by making one statement here and there, you can't satisfy this claim. Work no basis. There is nothing on record to show that you have worked for 240 days in a year. In fact, you yourself don't know, or maybe you know, therefore you have made this application under RTI. You are not yourself aware of how much work you have done. On the one hand, you are relying on a certificate of 2008 to say I'm working from such a long time. You make a representation before the authorities. Please tell me how many days I have worked.
Records are not provided to us.
You are working, then it is for you to assert that, look, I have worked on so many days from this period to this period.
That I have made my case in the original application.
No, you have not. Very unfortunate. You have not, even in your OA, you are not. We have just gone through it. You say on no work, no pay basis. That doesn't mean 240 days in. Plus, that the court is not sitting in appeal. This writ court is not sitting in appeal. Yes. Take.
And that requirement is not in.
All right, heard learned counsel for the petition.
Item number 10.
But I am for that. I am for the,
Date is on 15 February 2020.
Next date,
no, but the
15 February.
no, but kindly see, this original application has been filed before the learned tribunal.
Sorry, 29th April 2020.
Now, my lord, what happened?
29th April 2020.
Boludi, let me prove something. But before the tribunal challenging the matter of impugned order, which is page 69. Now we kindly see the order of the learned tribunal. But the tribunal held that this matter should be heard by the division bench. But thereafter, we can see 28th April 2023. Thereafter, there is no division bench at all. And petitioner before lordship is 70 years old. Now, there is no bench at all. I have annexed all the orders, my lord. Page 75 is the order of the learned tribunal, dated 28th April 2023.
What is your relief?
My relief is, my lord, I have made that in view of the order of the Honorable Supreme Court, my lord, the respondent, my lord, filed, issued a memorandum which is page 39. Page 39 of my petition. I have made prayer that in terms of this memorandum, I should be given the benefit for career advancement scheme as well as along with the modified advance scheme.
You want ACP, benefit
ACP,
of ACP?
yes, ACP, yes, ACP. So Supreme Court, on the basis of this matter, the Supreme Court let down, this memorandum has been issued. And if your lordship kindly come to page, yes.
Whether
But
issued,
page 44.
whether issued in compliance of the Supreme Court order or
Yes.
issued by the authorities themselves,
Yes,
you have to show that you are eligible.
my lord.
That is all. So
My lord.
therefore, Supreme Court is not relevant. Let us see what is the ACP benefit that you are claiming.
Yes, my lord, can I come to page 44 of that notification? Page 44. But yes, I'm coming, my lord. May I read my last paragraph? The undersigned is further directed to state that the amends who were drawing pay scale number 7 or 9 in basic grade pursuant to the order of the court will also be entitled to scale number 6 and 8 as aforesaid, aforestated with effect from 1/1/96. The pay of amends who were in receipt of pay under the care advance scheme with reference to scale 7 or 9 achieved through the order of the court will be fixed in the revised scale number 7 Sansas Rupa. Next page, page 45. Sansas. They will also be allowed to exercise option where necessary for fixation of pay under ROPA Rule 1998 within 60 days from the date of issuance of the memorandum. There will be no recovery of overdrawn till Sansas at all. Their pay is to be fixed in such a manner so that they do not receive less than the total pay that they were drawing. The undersigned also directed to state that all the amends will be entitled to benefit of modified career advance scheme under RUPA rules. The petitioner was appointed as Amid and he retired as revenue inspector. But I have annexed an order, but of the same another person, who was, I have annexed this page. The order, is based similar circumstances. The tribunal passed order, and on the basis of the order, he got the benefit. The page 49, the type copy is 50, the order of the learned tribunal. This person also, Hiralal, also, he was revenue inspector. Page 49, my lord.
the order I have annexed. Order of the tribunal. I have given the type copy also, my lord, next page. Page 52, the type copy, relevant page, my lord. We, however, hold that the tribunal is not the correct forum for appreciation of the problem relating to such pay fixation, and hence for affording opportunity to the petitioners for redressal of the relief. We direct that the matter should be referred to the Director of Land Records and Survey and Joint Land Reform Commissioner, West Bengal, for examination whether the pay fixation made in favor of the petitioner on 13/1/2009 has been correctly done in compliance with the order of the Honorable Supreme Court of India, and if there is any scope of refixation and to remove the existing anomaly in the pay of the petitioners, if any, and the entire exercise must be done within a period of 4 weeks, 4 months from the communication of this order, after giving a reasonable opportunity of hearing to the petitioner or their legal representatives. But in view of this order, my lord, the order was passed, page 55. Considering the earlier circular memorandum. Page 55. And the concerned authority, my lord, consider page 57, consider the memorandum, my lord, which I have referred, my lord, at page 39.
Order passed on your claim.
No, this is another person who is also similarly, my lord, he is also a revenue inspector.
Where is your claim?
My claim is my lord, prayer. Kindly.
Where is your claim before the authority? You
My,
must have
my
made
prayer is my lord, at page, my lord, kindly see. Prayer
One
is
page for setting effect, the memo dated page 69.
yes.
69.
69 is the I have challenged the 69, and prayer is
page 69.
yes.
This is the order passed on your case.
Yes. My lord, page 69 is the impugned order.
Anything?
Page 69 is the impugned order.
Rejected.
Page 69 is the impugned order.
When it has been found on page 73, hence after taking into consideration the facts mentioned above, it's clearly said that applicant may have been strictly held in terms of the judgment of the Honorable Supreme Court and in terms of the order of the Finance Department audit bench. So there is no question of further revision of pay of the applicant.
But this is but in the finding, but the same director passed order on the basis of which another person is given benefit, on the relying on the same memorandum, which was passed in view of the order of the Supreme Court. Yes, he also passed this order, earlier order. No affidavit has been used by the state respondent.
Victory Memorial.
দিয়েছো তুমি দিয়েছো ট্রাইব্যুনালে দিয়েছো reply. Tribunal. তখন দাও। Tribunal তো দেওয়া কিছু। Tribunal দিয়েছে।
It's not consecutive. It has 2020.
And your application is pending since?
Since 2023, my lord, last, my lord, it is, yes.
It has been
23.
fixed in April. What is the urgency? You can this
But
just
urgency,
this is something which can be given to you arrears if at all required.
Yes, my lord, but
Why the
petition
High
is,
Court should take up the matter right now?
my lord, the
There are
petition is 70 years, yes, but there is no division bench. That is the predicament we are facing, my lord. So we are going
Therefore,
and,
we are going through. If there is something that you are left remediless,
no, I'm not, but there is no division bench, my lord, since 2023.
therefore,
Now we are 25, my lord. So
waited
petition is
so long.
70 years, my lord. This is only this is, my lord. That's why, my lord, this is the predicament we are facing. That they are old, my lord. They
There is nothing. How long they will wait?
But according to the order of the Supreme Court, single bench can hear it. There is no difficulty.
But your single bench says no. I will not hear it.
yes.
No, but Iris has not been challenged. That's why. If according to H. on the point, if Iris is challenged, then judicial member and administrative member. There is no violation. In administrative order passed by the rate of.
But why your member is saying that I will not hear it?
Yes.
Very difficult for me because this is not my employee.
Here also we are going and coming.
But the position is difficult. Now from 2021, central government has taken our power of the state government.
For
Appointment is a different.
2022, there is no division bench.
File an opposition. We'll see.
My lord.
File opposition. For filing affidavit in opposition.
Grateful trustee.
শুধু ভলিউম 4টা দিন শুধু পাইলটকে ভলিউম 4টা দিন 1 2 3টা লাগবে না
Item number 11.
11 মানে আইপিএফ দি শুধু 4টা দাও শুধু 4 মানে 11 আই অ্যাপিএফ দি পিটিশনার্স মানে শুধু 4টা দিন হ্যাঁ ভলিউম 4 মানে only volume 4 is required other volumes are not required শুধু 4টা দাও 4টা শুধু 4 হ্যাঁ but here the petitioners are well, health assistant female. Now, what has happened is that your lordship kindly takes up volume 4 once. Well, kindly hear me for once, then your lordship kindly sees the order impugned.
What do you want us to see?
27 February 20.
What do you want us to see?
But the volume 4. Now, the kindly before going into the impugned order, but it's a very short case where the petitioners are kindly hear me for 1 minute. Are health assistant female, but they are placed in various parts of West Bengal and they are discharging their duties. What has happened is similarly placed candidates approach the High Court, where the High
Yes.
where the High Court has directed the Director of Health Service to consider the issue of their transfer to home district or home block. But that order was complied with by the.
Yes. Give us volume 1. Yes.
But that order was complied with by the Director of Health Service. But in volume 4, the order of the High Court and the recent order of the Health Service is there. So at volume 1, Malad will find at page 82, the original application is annexed. Page 82. দুটো
My husband wants to go to the bed certificate. Can you see the order, impugned order, pass for that order?
আমি আসছি
He will show us. Don't
I
worry.
will. There is no escaping route. I'll place everything.
No, let us see the impugned order. You have said that you approach this court.
I
that
approach this court
We are female workers. We want to be posted somewhere.
in their home districts.
All
Now,
home
yes. Now, the High Court has directed the Director of Health Service
To decide.
to
We have
decide.
Decided.
Now,
So let us
here,
see the decision.
but I tell you, Your Lordship, here the difficulty is why I have come to this High Court. In this petition, we approach the High Court for a similar order. The High Court found that these kind of cases can be dealt with by the tribunal. And the High Court has sent this matter to the tribunal. Justice Arindam Mukherjee's order. I have annexed it. But we went to the tribunal. Now the tribunal has given a date after 3 months. 27th of February 2025 is the next date. We are aggrieved by the order because the order was passed in November, 20th November. By this time, the second, our next batch, the second batch, their result has already been published. And they will be placed in their home district at any point of time. What we are on, what we seek before the tribunal is that kindly pass this similar order directing the health secretary or the Director of Health Service to consider our case, which the Director of Health Service has done.
You say that earlier such order was passed by the High Court.
High Court.
Where is that order?
Kindly turns to, yes. Your Lordship kindly turns to page 821, volume 4. 4. ওইটাই দরকার. That is what is important. 821.
21 or 24?
821. Sorry, I'm sorry. It is, just a second.
Neither 21 nor 24.
Just a second. Just a second. No. I'm telling you. Just a second. Give me 1 second.
Come to page 919.
But at 912.
Yes.
912.
Yes.
Here on 28th of May 2024, a writ petition was moved by Ranu Hajra and others. But may I read it? 912. আচ্ছা এই দুটো কপি একটু জজ সাহেবকে দিন তো।
You are party to this WPA 149.
But we were not, but our similarly situated candidates of our group, they came to the High Court. We were not there. We came to the second round.
अरे बाबा दारान ना दादा.
So all right, so this is not an order passed on your case.
Not on my case, but we have sent. But now kindly sees this order was complied with by the state director of health service. Kindly turns to.
May have been. That does not mean anything. You are before a division bench.
Yes, kindly give me two minutes time.
Yes.
But kindly turns to page 917. I have given the fresh copy to your lordship. Just now. It is lordship ke di. The fresh copy ta dilam.
917.
Yes.
Yes.
দিচ্ছি fresh copy দিচ্ছি.
Give them a copy also.
Yes,
How
yes,
they will.
yes. দিচ্ছি একটা copy আছে পড়ে দিচ্ছি.
Again, you are relying upon something passed in somebody else's case.
But kindly allows me 2-3 minutes.
Yes.
Here the order was complied with by the director of health service. Kindly see the ordering portion. Not so what.
So nothing was done.
Yes, they said that in the
Nothing
above
was done, we'll keep considering it as and when posting is done to the extent
Yes.
possible. So the fact remains you have no right to be posted at your home.
But
It will be as per administrative exigency. They will take a decision.
Absolutely.
That is it.
But exactly this order we want.
You don't need.
Why? But
This is an order which is not limited to the beneficiaries of this order.
It is. Kindly,
See the last paragraph.
but last paragraph I'm reading it for your lordship.
Last paragraph in the above.
In the above.
Please read.
Yes, in the above, although it was felt that the petitioners are facing much difficulty in their place of posting, which is far away from their home district, then too, this department has no other alternative but to persist with the existing order. At the same time, it is assured that the administrative department would consider the case of the petitioner as much as practicable when the next batch of health assistant female will get the order of posting. Now, the next batch has passed out. They are awaiting for their posting. Now, the difficulty is our case has not been considered by the DHS.
Challenge this order.
No. We are harping on this order. We are banking on this order. Because the Director of Health Services said that yes, we are facing much difficulty because we are 21, 22 years old, aged, young ladies. We are posted in 300, 400 kilometers away from our home. So when there is vacancy, we may be, our case may be considered. Only this much.
Tribunal will consider why should we interfere at this stage.
No. I'm not here to interfere. But what I'm on is, as the next batch has already passed out and they are
not before us.
No, they are not before us.
Then therefore.
Now, the difficulty is, if the tribunal has given a date in February and by this time they are appointed, then
there is no material to show that before that date they will already be appointed and before that date the order of transfer and posting will be done. Everything will be done by 27th February. There is no basis to say that.
I tell you, Lordship, as the what I am on is, why I have come to this court. These are the merit list that has been published. And
don't give us anything which is not before the tribunal. We are not going to accept it. Sorry.
These papers.
No.
These
not
list,
like that. Not like that.
Very well.
I'm not inclined to
very
accept.
Well. What I am on is, as the result have been published, there is every possibility that the fresh batch will be posted to
prevents you from asking the tribunal to recall the order and fix it on an earlier date.
We prayed on that day, but kindly consider the case.
There is an application in this regard.
Application I cannot make, but I have questioned the order.
Why can't you make such an application?
But your lordship is aware of the condition of the tribunal. It is one man.
Of anything, sir. Sorry.
It is one man who is doing.
You have invoked the jurisdiction of the tribunal.
True.
You are there before the tribunal for
True.
the relief. If there is something which you feel is urgent, which requires preponing or recalling of the date, you are not remediless. This is not a circumstance.
That is true.
In which the High Court should start interfering in these matters because there is a date fixed after 3 weeks. Therefore, the High Court should.
Not 3 weeks, after 4 months. The matter was moved in November. The
Now-
date was
now
given in
when
February.
We are taking it up now.
Yes.
It's on 27th February.
But kindly see, when I have filed this petition.
That may be, but nothing has happened till now. So all the more your apprehension is unfounded.
But
It
only
was a baseless and just
only one thing.
apprehension.
Yes, apprehension.
That is, apprehension is not sufficient.
But only
You
one.
must have a real and tangible threat.
But only one
Apprehension
request.
in your mind is not enough.
But only one request to your lordship.
Yes.
Only one request. But if the
We will not pass any orders. We are very conscious. This is not the time for passing any.
then our right will go. If the next batch will be posted to their home district, our right will go.
We don't know.
We are the senior
When
people.
result will be published, when they were posting orders will be issued. We don't know anything. Whether the select list.
But let the state.
Not the stage. We are not going to enter into this issue. We are not going to take the thing away from the tribunal at this stage. This is not the scope of our jurisdiction.
I know, Malan. I know.
Paragraph 98, 99, 100 of L. Chandrakumar judgment. You must have read it 10 times. This is the court of first contact. Why should we come into? In an extraordinary circumstance, we are not denuded of our jurisdiction. We realize that. True. It's hardly anything. You are seeking posting in a home district, and for that you want that the matter should be taken up by the High Court. You have no right, first of all.
But
you have no right which you are asserting.
But
we may observe that.
No.
We are really surprised how such an order has been passed.
But
there is no rule which requires your posting in the home district. There is no right. It's a matter of posting.
But High Court has
the law very well in this regard. It's a purely matter of administrative exigency.
True.
Even if there are orders governing the field, they are not mandatory. We all know the legal position. This is the subject matter before us.
But the High Court order has been considered and acted upon.
And you are relying on a single judge judgment before.
Yeah, no. But that has been acted upon by the by the department.
That makes it binding on the division bench.
No, not at all. But only. But the young ladies have come.
Nothing which can be done.
Only some sympathy. But they are 21, 22 years young ladies. But they are posted 300, 400 kilometers away from their home district.
Only waiting because.
Well, kindly grant that liberty to me.
Third learned counsel for the petitioner and the learned state.
Let me come with other better cases. Huh?
For preponing or interim relief. Preponing or interim relief. Preponing or interim relief.
Item number 12.
Journal will not say that Yes.
My lord, item number 12, my lord, I am for the petitioner, my lord, learned advocate, my lord, Gaji Farooq Hussain, my lord, engaged to the another court, my lord. Kindly, my lord, not to.
My lord, in this matter, I am appealing for the response number 4, my lord.
Yes.
Item number 13.
In presence of learned counsel for the respondents, matter is adjourned for the day on prayer made by the petitioner's counsel. Yes.
My lord, in item number 13, I beg to appear on behalf of the applicant. This is my affidavit of service. Uh, 13. My lord, I am for the applicant in this matter. My lord, so far the matter is concerned, the impugned order dated 14th of November 2024.
What happened?
My lord, the petitioner is a lady teacher after rendering more than.
You want transfer to a particular place, or
Yes.
you want not to be transferred?
I want transfer.
Yes.
Now, my lord.
Under which provision your claim is enforceable?
My lord, transfer is being allowed by the state authorities. And my lord, in the order, there is a factual.
You are working as
an assistant mistress, that is assistant teacher in a government school, which is distant.
Teacher in a government
School.
Where?
At Kuch Bihar, 697 kilometers from my residence for more than 11 years.
Kuch Bihar.
Kuch Bihar, they're not Bengal. It's a distance of 697 kilometers. I have already rendered 11 years of my continuous service. Now, my lord,
And you want to be posted where?
Either any school in Kolkata or North 24 Parganas. Two. Kolkata or North 24 Parganas.
So you want to go further away from your residence?
No, it is nearer. It would be nearer to my residence. Kuch Bihar is at North Bengal, my lord.
Yes.
So I will.
Now you said 97 kilometers from your residence.
697 kilometers between residence and the school.
Yes. And your right is enforceable under which provision?
My lord, the state, upon making application, allows transfer. My lord, kindly takes the order impugned for once. On which ground? On factual error as well as on legal error, the order has been passed.
I'm asking you a preliminary question.
Yes.
You want a particular relief from the authority.
Yes.
You want posting convenient to your place of residence.
Yes.
Under which rule or provision such a relief is enforceable?
Yes, it is the authority to decide. Now what happens? They make the applications. Authorities consider.
What is your right?
Yes.
What is your right?
My
That
right.
it must be allowed to a place near your residence.
Yes, my lord. The right is the procedure is that we apply to the concerned authority.
Where is that procedure? Let us see.
No, it happens at their administrative fiat. It happens
It's a
at their
matter of
administrative
administrative discretion.
Discretion, absolutely.
Therefore, why are you before the court?
Because the decision,
decide
no,
whatever
decision has wrongly been taken. That is why I have come before your lordship.
can be wrong if it offends any provision or defeats your right.
Factually.
Therefore, we are asking you,
Yes.
what is the right which was offended or what is the rule which was violated?
Administrative decision of the authorities, but they have wrongly exercised that because, my lord, there is a factual error. They say there is no vacancy, but there is a vacancy. I can kindly take the impugned order for
Even
once.
if there is a vacancy, let us take it that there is a vacancy.
Yes.
Then
they have
not get a right to go there.
No, they are allowing other teachers for transfer.
Maybe you are still their transfers.
No, they
Who's
have not.
stopping you?
No, they have rejected my claim earlier occasion on wrong considerations. The decision-making process is under challenge before your lordship. Kindly take page 128 for once.
128 is their decision.
No, it's the impugned order by the tribunal.
That's what we are saying. No, where is their decision?
Yes, my lord. Their decision is at page number 118.
118.
My lord. They may reject me on proper ground, but on absolute factual error, they have rejected me.
It's a composite order dealing with various or just your?
My case only my case, because pursuant to earlier direction, it has been passed. The relevant is 3 and 4.
Yes.
My lord, so far page 118 is concerned. So far point number 3 is concerned, there is an error. First of all, the senior teacher had only applied for district Kolkata. I applied for district Kolkata as well as North 24 Parganas. Even if for sake of argument, we consider that she applied for being a senior teacher, applied for Kolkata, I may be considered for North 24 Parganas, for which there is no application. One. Secondly, merely because a senior teacher had applied for transfer without taking any step, that does not act as a fetter for me for being considered for transfer. Anybody can make an application and wait for it. Maybe today it is not necessary for her. Just because she had made an application, my right cannot be extinguished for consideration. One. Secondly, kindly take, my lord,
You're right. That is what we are asking you. Where is the right?
it is a decision of the authorities, absolutely. But
What is
on
the right? That
no,
is
the
that's
decision.
the preliminary issue we asked you.
Yes,
You want then everybody will start making an application for posting at their home.
absolutely,
The
absolutely. I
entire
bow down to lord.
administration will collapse.
The right is, my
The
lord, of
education in
consideration.
the schools will collapse.
No, there are sufficient teachers in the school now, my lord.
We
My
don't
right.
know. We don't know. It is for them to decide. We
Yes,
are
I am
not to
telling you,
look
lord.
into it.
Yes, yes, yes,
We
my
are
lord.
not to look into it as settled
Yes,
law.
yes. My
This is
humble
an
submission.
administrative exigency.
Yes.
There is no right being espoused in these applications.
No,
This
I
is,
tell you, well, there are two types of transfer. One is own seeking, one is
No, no,
administrative
no,
exit. I'm showing to your lordship. Now, my lord,
we are not inclined. Sorry.
no, may I just
Nothing to
may I just submit, my lord? My lord, this is their discretion, absolutely, but it has to be exercised properly. Now, there is a
No,
factual
sir.
error for North 24 Parganas. They have not considered me.
Don't know. We are saying even if we take it that there is a vacancy,
There are
there is
vacancies.
no right.
No, right
Therefore,
of
there is no
consideration.
issue to be considered.
They have wrongly said there is no vacancy, but there is.
Maybe
No, there is
there
vacancy.
may be.
There is
Still, you
vacancy.
will have no right. So that is not a relevant issue. That is what we
Absolutely,
are saying.
absolutely. My right is
No
for
relevance
my
of
lord,
that fact being wrongly noted. That will not improve your case in any
my
way.
lord. My right is for fair consideration. I
No,
may
sir,
not be.
for transfer.
I only
you
consideration.
make an application and they may decide that will not be an enforceable claim through a court.
Absolutely, my lord. I
That
understand.
much we are very clear.
Only one thing, my lord.
We
If
find no infirmity in the tribunal's order. Sorry.
yes, my lord, may I just submit one thing?
Yes.
May I just submit one thing? It is absolutely correct as has fallen from your lordship. It is their decision based upon which I have to rely, and it is my right is for fair consideration of my
No,
application.
sir, we don't know how that right has been given to you.
Because I show your lordship,
Where
they
is the
have
order based on which the application was made by you?
lordship.
You made this application
Yes,
pursuant to some order passed earlier by the tribunal.
yes.
Where is that?
That is the order for consideration. That is at page number. No, no, target order. That is at 116, my lord. हाँ 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 ठीक ठीक है
As per rules. As per which rules?
then my lord, I'll
Very
just come back on the
surprising.
next day.
We can take this order also into consideration today. Under which rules?
The state also not relied to any rules.
You are
Yes, yes.
trying to enforce this order. We are asking you.
Yes.
You sought a direction from
I
the
understand,
tribunal
ma'am.
that in terms of the rules.
I understand.
Which rules?
My lord, may I just come back with an instruction? I'll just confirm, my lord. Just give me one.
Today.
Not today.
As today, not today.
But may I come back on 29th?
Sorry, sir.
29th. I will not be here in 27 on 27th, my lord.
Tomorrow.
Very well. I'll come on 24th, my lord.
Not today means tomorrow.
Tomorrow is holiday, or 24th, my lord. I'll come back. Yes. Grateful to your lordship. I'm extremely grateful to your lordship. Take it up.
এটা কার রয়ে গেছে এই এটা তোদের রয়ে গেছে রে অ্যাফিডেভিট অফ সার্ভিস দিলে কন্ডনে কোথায় টাইম
Yes.
Lord, I am for the petitioner.
Item number 14.
Lord, may I
Lord,
file?
My lord, with the lordship kind leave, my lord, I am appearing in online mode. I appear for the respondent number 4 in the instant petition.
Number 4 is a private respondent.
No, the fourth respondent is the selection commission.
It's a West Bengal Staff Selection Commission, my lord.
And Lord, the petitioner is aggrieved by an order whereby his application for condonation of delay was rejected by the learned state commission. Commission?
State commission.
Administrative tribunal. Sorry, I stand corrected. By the state administrative tribunal. Lordship will kindly take up the impugned order.
18 November.
That is the order of 18 November 2020.
Condonation under which provision?
Lordship will kindly take up my application. It is appearing as at page 111, Lordship. It is under section 21(3) of the Administrative Tribunal Act, read with section 5 of the Limitation Act.
21(3).
Yes.
Section 21. Well, may I permit to hand over the copy?
We have it. We have 2 copies. The Administrative Tribunals Act. See, come and see.
You got it.
Oh yeah, million.
Put it in, put it in. Put it in.
We'll come back and see. We'll come back.
The petitioner lordship was aggrieved by an order passed by the
So this is
state
against, this is a selling some reasoned order.
yes, lordship, where his application
1
for
year.
limitation is lordship 1
1
year.
year from the date of the order.
The date of the order, lordship, here, lordship, he has approached it after 2300 days, lordship. The delay is of 2300 days where the intervening COVID period was also there. So. No, sir. Sir. এটা আপনার বলে? মানে এটা তো আমাদের বই, এটা আমাদের বই, এই কিনে আনা হয়েছে শুধু। আপনার বইটা স্যার মানে জজ সাহেবদের দিয়েছিলেন। ও দেন?
Yes.
Lordship, on the point of law, there is nothing. It is just that the petitioner is approaching my lords with a folded hand, lordship, that they may be allowed to contest the matter on merit, lordship, because lordship, 157 candidates were given, were called for recruitment, lordship, 185 posts were vacant. There was delay, lordship, that is beyond question, lordship.
How many years?
Lordship, that translates to 6 years, lordship, almost. And it is only with folded hands, lordship.
What has been challenged?
Lordship, challenge is, lordship, the other posts which have been left vacant. Lordship has read the order. There was the notification, the advertisement was for 185 posts, out of which 157 successful candidates were recruited. The rest vacant.
Not read the order. What is the date of the order?
That is, lordship, the order dated 18th of November 2024.
Just give us.
Yes, lordship.
What have you assigned? What reason you have assigned in your application?
Lordship will kindly take up page number 117 onwards. This is my application for condonation of delay, lordship. Paragraph 12 onwards, may I just place for my lord's convenience?
12 onwards.
Yes, lordship. The applicant state that since 2018, applicants had tried to hand over written representations to the office of the respondent authorities, but the same had been refused by the respondent, citing the process of recruitment in respect of post of such and such is still under consideration, and that the names of the applicants herein will be considered for appointment. Furthermore, it was also conveyed to the applicants from the office of the respondent authorities that different applications have been filed by different individuals, challenging the process of recruitment to the post of fire engine fire engine operator cum driver before the honorable forum, pursuant to which the process of recruitment has been stalled, and that the respondent authorities will take deliberate decision as to the process of recruitment on the basis of the outcome of the applications pending before this honorable forum. The applicants have visited the office of the respondent authorities on several occasions to ascertain as to what was the outcome of the status of their appointment, but all this while they were given the assurance that their appointment is under consideration and they will be intimated soon. that it had been informed by the respondent authorities that the process of recruitment has been kept in abeyance due to several litigations having been filed by other candidates who had also appeared in the same recruitment process, and that a decision will be soon reached by the government after decisions have been given by the Honorable Court and or Tribunal. Thereafter, the applicants had made several representations to your good offices regarding the outcome of their appointment, but they have not received any reply from your good offices till date. That the applicants are in a state of limbo as to the outcome of their recruitment. It is pertinent to mention here that applicants have come to knowledge that their posts are lying vacant in terms of the process of recruitment initiated on the basis of notification published in the year 2014 for recruitment and appointment of 185 posts. That the applicants have made representations dated 25th of June 2024 through their learned advocate, but till date they have received no reply thereof. So, Lordship, it is an admitted position that there are
Where is the result?
Pardon, my lords?
Where is the result of 18 of 2025 for 18?
I could not get your lordships.
The result of the recruitment process was published on 25 for 18.
Yes,
Where is that?
Lordship will kindly take up Annexure P6 at page 79. আমার নামটা and if
So there is
this is the list of the candidates who were recruited.
only the select list has been published.
Yes, kindly takes up page 52.
There is no merit list.
Page 52, if my lord takes up.
Yes.
I was called for recruitment, lordship.
That means nothing.
That is
After the process of recruitment, any merit list was published.
No,
you know
no,
where you stand.
Subject to.
You don't know where you stand.
No, lordship.
Whether you are at
I qualified till the interview
serial
round. I was
157, whether you are at serial 157 or you are at serial 1 lakh, you don't know.
no, because lordship, if my lord kindly takes up page 52, my name appears at page.
How does that matter?
Yes, I was one of the
There must
candidates who was called for the interview.
Candidates called for interview. Maybe thrice, at least. At least
I
the thrice of
understand.
number.
I understand what is calling for. But lordship, my only prayer is for consideration, lordship, because 185, it is an admitted position that 28 positions are still lying vacant. That has been noted by the learned tribunal in the lordship order.
All right.
So lordship,
Learned counsel for the petitioner and learned counsel for the respondent state. The petitioner has participated in a recruitment process
before the tribunal, Lordship, with regard to this recruitment process, other persons have already filed, which is pending. Lordship, what I very humbly pray for is if I may be allowed to be impleaded in
Sorry,
that.
no observation in that. Can be done at this period. Yes, respond number so and so.
I appear with Mr. Vishwarup Nandi, my lord, for respondent number 4.
I am grateful.
Deep with this, no.
Now, tell me. Now, excuse me.
Item number 15.
14. 15. Okay.
Well, item number 15, I am appearing on behalf of the petitioner, Lordship.
I've got a preliminary objections about the duty of that.
Yes.
For the same section of petitioner moved a original application before the tribunal challenging the selection process conducted by the police recruitment board.
By the
Police Recruitment Board.
police recruit, the same applicants.
Same applicant. I did in particular.
This is the second attempt.
Then Malad challenged this before December court. Bench was presided by Justice, Chief Justice and Justice another General Judge. Rejected the application. Review application was filed. Rejected. Then when the same petitioner suppressing this order of the division bench of December court, filed his original application.
No, my lord, we are not suppressing any fact before the tribunal, Lordship. And why we filed that application before the tribunal as well as.
Let him raise his objection. Yes.
But there, what is the plea there? That watermarks was not disclosed, then some question papers was.
No, that is on merit. So your preliminary objection is that suppressing all these facts they have moved. Let us see from the application that they have not disclosed these facts. You have disclosed this in your application.
Yes, Lordship, kindly come to my OA application, Lordship.
Paragraph?
At page. Page 41, starts from page 41, my OA application, Lordship.
Where have you said about the matter being earlier decided, carried up to the High Court, review and thereafter?
Yes, Lordship. Well, I'd kindly come to page 57, Lordship. Well, I'd kindly come to page 56, Lordship. Paragraph number 12, Lordship. That your petitioner states that after publication of final result of the subject recruitment process in the official website of the board, all the applicants visited the official website of the board and accessed the link to know their individual marks, and they came to know only about their individual total marks without any breakup of marks.
We are asking you to show where have you said that after disposal of the earlier OA, you have moved the High Court and the matter has been carried up in review. Come to that. Why are you reading this?
Yes, Lordship. I said I am very.
We are only on the preliminary objection.
Yes, Lordship. I am specifically stated that
Yes.
because I annexed.
He alleges, he is saying that it is you have approached the tribunal suppressing these facts. So show that these facts were disclosed. That's all. What was the earlier OA filed by you? OA number?
Earlier
OA number 30 of 2020 and WPST number 9 of 2020.
Both was filed by these petitioners.
Yeah. And his serial number there, 82 of the earlier original application. Now the petitioner number 1.
Kindly come to page 68, Lordship.
May I hand over a chart? Who was the petitioner and who was the respondent?
No, in 430 there was a direction to prepare the panel afresh.
Afresh. My lord, kindly come to page 68, Lordship. That your applicant states that thereafter the said writ application were appeared before several benches on these Honorable High Court, and finally the said writ petition were finally adjudicated by the Division Bench of Honorable Chief Justice T.S. Sivagnanam and Honorable Justice Hiranmoy Bhattacharya by its judgment and dated 27 September 2023 with the following directions. Then I have written all the directions. Accordingly, the following directions are passed by this court upon the respondent authorities. The post against which the candidates whose name were not in the original merit list dated so and so were appointed shall be treated to be vacant.
You are of the reserved category.
If the applicant who have filed these applications, they are from several categories, my lord. Not only the reserved category and not only the general category or.
So what did you approach the tribunal for now?
My lord, kindly come to the order of Honorable Chief Justice, my lord, dated 27/9/2023.
That we have seen. He has said that the posts may be taken as kept as vacant and treated under these.
No, my lord, I am on that, not on that point. What I am on that was not adjudicated by the earlier bench, lordship. I am on that the question which are wrongly answered by through the RTI. I am challenging that question, and that was not adjudicated by the earlier bench, lordship. I can satisfy your lordship from the judgment that
the reply under RTI was not the issue before the court in the earlier proceeding.
Yes, lordship. I filed the MA application before his lordship, before their lordship, but their lordship was of the view that I am agitated the grievance in my OA application. But that was not adjudicated in the OA application. That is why their lordship was denied to interfere in the question of answer keys.
No, we are not able to understand. At least for myself, I am not able to understand. You are saying that there was some reply given under RTI. On which issue?
That question issue. Wrong question answer.
Wrong question. So you ask them whether the question is wrong or not.
Yes, lordship. Now my challenge, and that was not adjudicated by the earlier bench, lordship.
You ask the authorities that whether these questions are right or wrong.
No, I am not at all the authority. Whatever.
What was your query under RTI?
Yes, what is the answer of that question?
What is the answer of this?
Answer was provided, that is a wrong answer key. As per my view, that was a wrong answer key was provided.
So wrong answer key was provided, but what was the query under RTI?
My lord, kindly come to the query, my lord. Baji Xerox. My first query is at page 127. Information short, my lord, dated 7th.
This is not your query. This is a reply by the public information officer. We are asking you, what is your query?
Query, I am giving. Query, query গুলো কোথায়?
Photo reply.
Well, due to inadvertence, that query was not annexed in my petition. My lord, later opportunity be given to file the.
Oh, let us see. Not there, then not.
এবার এখানে তো স্পষ্ট করে লেখাই আছে in response to this petition the following information is furnished. As per answer key, this is the correct answer. As per answer key.
पाँच तारीख के तो ट्रेन शुरू बनाते जल्दी शोना जल्दी इंटरफेयर नाम की ट्यूशन है वो इसका ऑर्डर कहाँ है मेरा पेज बांधा हुआ था मुड़ा हुआ था मेरा ओए दो दिस इज नॉट माय ओए पेज कहाँ क्या लिखा है इसका पेज का कितना होगा सभी पेज कितना होगा इसका
इसके पहले हाँ
तो सही नहीं पा रहे हैं
सर का सही होगा
कितना सीरियल
इसके
नंबर
पहले का 200 यहाँ से पढ़ लेना
কি বোঝা যাচ্ছে একটাও পড়তে পারে
আপনার কাছে তো সব ফর্ম দিয়ে
সেরকম বলে কি রেট আছে বিক্রি হয়ে গেছে
ঠিক আছে পাঠিয়ে আমারও কিছু কাজ করে কোথায় গেল কিচ্ছু বলে যাচ্ছে না পড়া যাচ্ছে না আরটিআর একটা কপি রাখেন
अच्छा ভালো ছিল সেটা তো
Yes, so the tribunal had directed that the persons of the reserved category who had been appointed against unreserved, their name should be removed.
Yes,
And only the unreserved persons in order of merit should have been.
yes, Lordship.
The High Court said no, cannot be, whether they are reserved or not. The reserved can always cross over to the unreserved, other way it cannot be. So on that, it has been decided. So that is wrong.
I'm not before your lordship that reserve category, unreserved category. I'm not.
You were a petitioner there.
I am a petitioner there. I'm before your lordship. That is not my challenge. My challenge is that the wrong answer key, which was provided through RTI, that is my challenge. And
But
when
that issue you did not raise.
Yes, lordship. Kindly come to page 200 of their lordship's judgment. Kindly.
Yes.
But at issue number 7, where the non-publication of key answer was and the learned senior advocate, it was not, it was illegible. That is why
it has been considered by the division bench.
No, issue number 7 being purely factual cannot be allowed to be raised for the first time before this court.
Correct.
Because at the time of when we moved the original application, that time we were that answer key, what is the correct answer key, and then after the examination, they never published any answer key. So that is not in our domain. We don't know whether the question
are going to sit in appeal over the earlier division bench judgment.
Only that.
Or is the tribunal going to sit in appeal over the earlier?
No, I'm not going to appeal.
Essentially, that is what is happening. The division bench has decided an issue. You say it has decided it wrong.
That issue was not decided by the division.
No, it was decided. It said we will not go into it because it is issue not raised. That was rejected by the division. Then how the tribunal can go into this, if at all you had a forum? This is looks to be like a luxurious litigation. These matters should not be allowed to go casually. This is too much. A issue decided by division bench, you are raising it before the administrative tribunal and then coming again to the High Court. You have too much resources, that means. The issue is decided. Let's see page 20. Court is not inclined to entertain such a plea, but it's specifically rejected. Page 1. The court is not wrong in saying that it was not raised and we will not go into. You say why we did not raise, because we did not have. Now you want to raise this new issue before an inferior forum when already rejected by the higher court. And then you are back here. It appears to be too much. Can you do such a thing? There has to be a finality to court proceedings. It's not so casual. A person with resources cannot do this. He may be having, he or she, we don't know, he may be having a lot of resources, but this is not the way. Maybe inviting some consequence. Therefore, we are observing whatever we are observing. May proceed if you want. Yes. It's not the way. You want to show anything, you show it.
But we are of the client, my clients are of the opinion that though the court is not interfering in the matter, that is why the issue was not adjudicated by the court. That is why
we are asking you as a counsel, when you go through this paragraph 47, can you say that the division bench has not considered and decided the issue? You read it.
Well, the division bench denied,
considered, rejected.
The matter.
So we are inclined not to go into this issue for such and such reason.
Such and such reason.
Now the correctness of that reason you will raise before the tribunal again.
No, my lord, I am not before your lordship for the correctness of the reason.
What else are you raising before the tribunal? Once the issue is concluded by a higher court, what else are you not doing? You even tried for review. You wanted to re-agitate, you wanted to rehear, the court to rehear, court said, no, we will not rehear. And then instead of taking your remedies, you are appears to be a person with too much resources.
Lord, in this regard, I tender my apology for preferring this application, my lord. Kindly pass necessary order and we will test it our luck before the higher court. I tender my apology, lordship, in this regard, lordship. Grateful. Okay.
Affidavit. Not today. Dada. Oh, Dada.
In presence of the learned counsel for the state and after some argument, the learned counsel for the
Sixteen.
My lord, I am for the petitioner, my lord. My lord, the petitioner is the casual worker, my lord, of Irrigation and Waterway Department. My lord, the petitioner or other colleague are joined in this department, my lord, since 1992, my lord. Thereafter, my lord, in 2001, the petitioner and his colleague joined at the 2001.
working, sorry, you are working since?
I am working since 2092, my lord. Sorry, 1992.
As?
And my lord,
As?
as casual worker, my lord.
Casual worker since 92.
But my lord,
Yes,
in 2011,
yes.
they given me status of casual worker.
So prior
In 2001.
Prior to that, there is nothing.
No, my lord.
2001.
One.
Where is, so they gave you status of a casual worker.
Worker, my lord.
Then?
After, my lord, in the meantime, my lord, in 2001, my lord, the petitioner and his colleague joined the same time, but in 2001, except the petitioner, everyone got permanent employee status, my lord. 2001.
There is any payment of wages prior to 9/2/2001?
No, my lord.
No wages prior to 9/2/2001.
Yes, I got, my lord, with the colleague. My case is, my lord,
9/2/2001 is
Yes,
the
ma'am.
date with which effect from which they consider you as casual worker.
Yes, my lord.
9th February 2001.
9 February 2001.
So prior to 9th February 2001, did you ever receive any wages?
Yes, my lord.
So there is material to show.
It proved in my annexure P1, my lord.
Annexure? P1.
P1, page 20.
Sorry, my lord. P1 page 19, my lord.
19, yes.
Yes, my lord. The include the name
How
of
many? There is one petitioner, sole petitioner.
my lord. May I read, my lord?
You are alone, or there is more than one petitioner? How many petitioners, sir?
One, my lord. Only I. Okay. Yes, my lord. Mohammed Kaimuddin working since January 1992.
Yes. So prior to this letter, you were not working for 239 days. The last paragraph, read the last paragraph. The matter has been discussed with you. In a hereby recommend the matter to get your approval to increase the working day to 239 days per year. At the same time, inclusion of their name in the list of casual workers. So till that date, you are not working of 239 days per year. From that day, they have recommended that your working period should be increased to 239 days.
In the his of casual worker.
Prior to that,
What happened in this? What happened in this season thereafter?
He is a casual worker since 92.
What mistake he has committed?
Yes.
Page 21.
Yes.
Serial number 15.
Serial number?
15, my lord.
Yes.
Last number. Take Koimuddin, QA. He is permanent employee.
What is the last column?
Serial number 15. Sheikh Koimuddin.
Yes.
Have you not got it?
Yes.
Spelling is QAMUDDIN. Here by
Oh, come to without reading the first column, you are reading the last column.
Yes. The following,
Date of joining.
The following work charge employees of the division are hereby declared permanent and confirmed with effect from the dates as noted against their number, Rule 61 of the Bus Permit Service Rules 1979, with effect from 1979. Sheikh Koimuddin, serial number 15.
What is the first column after his name?
First column, date of joining.
What is his date of joining?
He is not there.
Just see what is his date of joining?
24 July
He is not
1996.
that person.
Huh?
He is not that person.
Please
get the tribunal.
My lord, kindly see the next page of the annexure 4, my lord. The due to spelling mistake, my lord, they given the.
Please get the can see the order of make Koimuddin alias Koimuddin.
So you have rejected it on this ground?
Yeah.
Where is that order? That he is imposter?
But the tribunal rejected on the ground that
Delay.
February 2021.
That is not an issue. Nobody has said that he is claiming against
No,
to be
but why got instruction that can you see that
you file opposition. You file opposition. File opposition. Land Council for the state to file opposition. Let the same be
And appearing for the state one. 70. Appearing for the number 6.
Yes.
My lord.
You don't want to give
The
the
authorities, my lord.
You don't want to furnish the requisite
my lord.
details.
My lord, no, my lord. That is not the
What
fact.
has the tribunal
Fact
said?
is that PPO, they are seeking, my lord, I have my father submitted nomination form with regard to the pension, that if he died, in that case, his wife will be entitled to pension. From the pension passbook, it is clearly written that pension holder. Your lordship kindly take the passbook, if your lordship kindly take. I do not have the PPO. Why? I have explained before the tribunal that actually
You are already beneficiary of the family pension.
No.
When did
Mother
when did your mother
predeceased?
When predeceased
The father. And father was receiving pension.
So from 89 you have not
No,
done
my lord.
anything.
The entitlement, my lord, in the year 2010, my lord,
How?
government issued memo that unmarried daughters will be extended family pension.
So from 2010 also, what were you doing?
My lord, I was unaware. I am a little educated and rural rustic woman. My lord, unmarried daughter. My lord, for which one it was not possible for me, in absence of any earning, my lord, to approach any learned advocate. And moreover, I learned it in the year 2017.
You what?
In the year 2017, I learned, and accordingly, I filed proper my application in the year 2018.
Father of the petitioner retired 50 years ago, in the year 1975.
Maybe.
That we have seen already. That's why we are asking him what he has been doing since. Forget about retirement. How is retirement important? Family pension will arise only if this person is dead.
Hello.
He has died in 89.
Yes.
But that is not relevant. 75 is not relevant. 89 is relevant. And in this case, 2010 is relevant.
Yes, but
since 2010 also.
My lord, after
does
that,
not
lord,
inspire
I
any
was not
confidence.
aware of the fact for which, my lord, the family pension cannot be denied, my lord, on the ground of delay. Paragraph 7 of the Tashamshin Jasmine.
First, family pension entitlement has to be shown, then only there is question of denial.
Yes, my lord. Yes,
So the tribunal
Yes,
has
madam.
allowed you
So
to show
kindly-
show your entitlement.
Yes, madam.
You say, I don't want to show my entitlement,
No,
you
no,
give
no,
it
no,
to me anyway.
no, no, fact is not that.
Then?
Fact is that actually due to devastating flood, the documents regarding service
Then how can
related
it cannot
papers
be-
will not was away. So I do not have the pension payment order, but I have produced the nomination form
Where is that?
P3. My lord, page 25. Received by the Treasury Officer, Malda.
And where is your, you are born in?
My lord.
When were you born?
My lord. 1964.
And you have not been mentioned by him. Even though you were born prior to his death, he has not mentioned you.
No, my lord.
Why?
Prior to, oh, but 1 year before, the wife died.
Please answer our question first.
My lord, my lord.
You are born in 74.
64.
64. He died in 89.
Yes, my lord.
All this time, and while he retired in 75, 11 years after you were born.
No,
He retired
after
11 years after you were born. But still he has not mentioned you as his nominee in respect of
the nominee wife was nominated, my lord. P3, my lord. He was alive.
This is the only thing you have.
My lord, and only thing is nomination forum.
This is
and
the only one you have.
Yes, my lord. And
You have nothing else.
no, I have produced it. Annexer, my lord. P5, kindly. Page 28. Ishan Chandra Borman. I have annexed the entire passbook. My lord, pension holder. Occupation pension holder. He received pension.
Where is, show us some your identity proof.
I have annexed the Aadhaar card. Page 23, P1. They are saying that I could not produce PPU, pension payment order.
And where is your first claim made before the authorities?
My lord. My lord, P8, page 49.
When have you made this application? 2018.
My lord, 2018. Pro forma application.
But can we appreciate one thing? But,
So your elder brother was getting the family pension?
My father.
Your elder brother, was he getting a family pension?
No, my lord. No.
No.
My father, my elder brother, my lord, expired in 2017.
After his expiring, you have made the application?
After the expiry of my father.
No, after the expiry of your elder brother.
Elder brother. He was not getting family pension.
So he was also not knowing that he is entitled to family pension. Nobody was knowing till 2008.
My lord, elder brother, my lord, was married, my lord.
So what?
Well, married person, my lord, cannot get family pension.
He was married even at the time of the father's death.
Yes, my lord.
In 89.
Yes, my lord.
There is an affidavit also.
not actually, only appreciate one thing. Although he is complaining just for the first time, he is saying that that the original PPO might have been flown away by flood or like that, but he has not raised any complaint before any local police station for GD or that.
We are asking you, why are you insisting on him supplying the PPO?
My lord, it is not possible for us to preserve for PPO in our office for so many years, sir. He retired in the year 1975 and he died in the year 1989, my lord.
He did not die. Her
My lord,
father died.
Our father died in the year 1989.
Yeah.
But
You have said anywhere that you don't have records of 1989.
my lord,
You are just now making a submission that it is not possible. Have you said anywhere that you don't have the records of 1989?
my lord, we asked them to
You have just now made a submission. We hope that you have made it with reference to some pleading made by your client. Has your client said that they don't have the PPO of 1989? If not, then why are you making such submission?
my lord,
You are here to assist us, not to just make any submission from the off the cuff.
I have to take instruction on that.
Then don't say anything like this. We are asking you a simple question. You are not doubting anything. You are just saying, give us the PPO now. You are the custodian of all records. You have made payments to her and you don't know what is the PPO number. She is giving you all the details of her father, the account in which you have remitted the earlier amounts, and still.
Father received pension, my lord, till 1989.
Obviously, he would have till he retired.
But I have to take instruction on that.
Affidavit in opposition be filed by the state council to stop. Where did he retire from? Where did he retire from?
My lord, from the office of the district register, Malda. When he was
He is a party here.
district register, yes, my lord.
Who is the respondent?
Respondent number 5.
The opposition shall continue.
My lord, item 18, I am paying for adjournment. Service is not complete, my lord.
Let us see whether service is required or not. On the first day, we are not required. You tell us whether any case. Yes, what is wrong with the order? 4 years you have worked for? Temporary period of only 4 months in a year. 73 to 84, 11 years. What is your entitlement? On 14 years, 6 months, what will be you be entitled to?
My lord, my senior will move.
That's great. Not today. Ask him to
My lord,
be here.
service is not complete, my lord.
করবো
19, 19, item number 19.
yes or no বলো Similar, I am appealing for the petitioner. I am for the petitioner. Affidavit service. This is relating to the compulsory appointment, the order passed. Your lordship can see the there is second phase litigation. Milord,
Why are you averse to giving an option?
option, milord, already, milord, I have given the option, milord. Because why I am approaching before this court, milord, the tribunal and high court, it is not a, my pleasure to approach before the loitering.
Therefore, we are asking you, why are you averse to
Because,
giving
milord, no reason order is passed. 2013, your lordship says the death of the husband of the petitioner, 2013. I made an application for appointment. That was not
He died while serving on which post?
the police personnel is husband, milord.
GRP. Government railway police.
GRP, constable, SI,
Constable.
Yes, so what is the date of his death?
Date of death, milord, that is the 16/11/2013.
All right. Then
milord,
your application.
Then milord, I made an application.
Then what happened?
Then family dispute, milord, they did not consider subject.
Family dispute.
Yes, the mother-in-law objected that he is not the wife of my son. Then approached to the civil court. I went to the civil court. I succeeded over there. After obtaining the order of the court, milord, civil court, milord, I approached before the authority concerned.
Can you give us the date on which the trial court passed the order?
Yes, I am giving the
Case number and date?
yes. Decision, milord, that was your logically says the production of the marriage and succession certificate on the date of competent court of law, that is annexure P2, your lordship will find all the document we have dated 7/1 of the such and such legal. Yes, I am coming to the.
Sir, please give us the page number, sir.
I will request. Title shoot number, your lordship. I am giving date. Title shoot number, milord, 1230 of 2015.
What is the date on which it was decreed?
Judgment, milord, that is the judgment dated, milord. Judgment and degree.
Is it on the record?
Yes, all.
Page, please give us the page.
No, it is second page, milord. Initially, I have approached before the tribunal, all the document was there. Here it was not there.
So what is the date of decree?
Yes, I am giving to them.
18/12/2017.
2017.
Yes.
Then, milord, I approached before the authority concerned, milord, for grant of appointment by virtue of the judgment of the such and such. That was not considered. Then, milord, I approached before the tribunal for consideration.
the what I have made before the authority concerned. The tribunal directed to consider the case of the petitioners. From that case, my lord, again this application has been started. My lord. Your lordship can see the order. OA number, your lordship can see
502 of 21.
Yes, 502, dated 13/6/2022.
Yes.
Then Miller petitioner received a radiogram message below your lordship can see the dated 5/12/2022 regarding the employment under comparison. Then Miller the aforesaid instruction on behalf of the SRP Miller, I face application before the authority concerned, Superintendent of Police, GRP, that is the SRP in short. Reason one, again, Miller, we have received another message from the Howrah SRP, that is the Inspector in charge, Bali, regarding the employment under exempted category. But it is on Miller, well, actually, Miller, geologically is astonished to receive that one more again, Miller, paragraph 13, Miller, through the Inspector Police Station regarding her employment after 10 years exempted category by message there asking her application and willingness to paragraph 13 page 7 post group D LDC such and such, but initially and then your logically says page bole dicchi to 7 page 7 paragraph 14, Milord, your application submit that he was completely clueless on the 5/12/2022. He was asked to submit an application mandatorily mentioning there is the post of Group C, Group D, and Lady Constable. Thereafter, Milord, in compliance of the aforesaid instruction and information on such and such, made a fresh application on 22nd December 22. That will be revealed from paragraph 14. And that was received by such and such authority concerned. And Miller endorsed the principle of naturally issued a message dated 13/23/23 and 14/4/23 with an illegal arbitrary such and such, stated that for your lordship see the paragraph date Miller only 19/4/23 again further prior concerned authority treating the same as a reminder as a compensate appointment. 15 paragraph 15 পড়ো। Ultimately, Miller, on 26/20 paragraph 16, 26/4/23, it is found, ideologically sees, on examination it is found, K.R. Mojumdar has become ineligible for recruitment to the post of constable in West Bengal without assigning any reason. That is then not good reason, Miller, not. Then I will say voice কত তখন ভয়েসটা কত হিসাব করে দেখো কে বলেছে তোমার কম্পালসেন্ট I can show you 42 তে পাওয়া যায়
What is your prayer before the tribunal?
Prayer Miller, only prayer Miller.
Before the tribunal, what was
yes
your
prayer for before the tribunal I have made and prayer for grant the appointment to the post of constable.
Where is
yes we annex the copy of the
where is the prayer in the tribunal?
Yes, I am placing the is there relief short for page 53 relief short for O is appended here with
Where is this 26/4 to 2023 order? Where is the communication of 26/4/23?
26 I have already annex, I have annex already pointed out before your lordship. 26, 4, P8. P8 in the read petition, P8. Just to that P8 on the wall.
Page 40. Page 40.
That is page 71.
40, 43. Page 40. Page 40, P8. টেনশন করো না, ওটা সেকেন্ড টাইম দিয়েছি, ওটা ওয়ের সঙ্গে গেছে।
No reasons.
Only asking myself, Miller, what is the examination and what is the foundation?
No reasons.
At the time of day, he was major.
She was?
Major. Then, there is a dispute between the.
That he has said. What is the reason? Why she is not eligible for? Come to page 71.
What a kind thing.
Come to page 71.
Yes. On exam found that Kabul has become ineligible for.
Why? Why?
Because of the age.
Where is
Where?
Where is that? So from this order. This order does not say anything.
No, there is a three-man committee,
Why she should not know what is the reason for her rejection? First, you make her, you compel her to make an application for 3 posts. Then 1 post you say not eligible, as if you are having arbitrary power to say whatever you want. Who is this person? Who has passed the order?
SRP.
What is this SRP? What does he think?
Superintendent, Railway Police.
But that was communicated on the basis of the.
How she will know? Where is the reason assigned?
The three-man committee report was placed before the authority on the basis of that. Yes. But what she wants an appointment on compulsion ground. We offered an appointment as a group D according to the scheme. Now she wants that appointment, he should be appointed as a constable.
Why not?
No, but a constable.
Why not?
But a constable, there is a recruitment rules.
Why not? Why not?
But a constables to be recruited on a particular age.
Then you must tell her this. That's why we are saying why not?
But and physically fit, he must.
There is nothing. You only say not considered as lady constable, not fit to be. No, what can we see? There is nothing in the order. How can we see? Nobody can decide.
On the basis of this order?
No, this order is unsustainable. This is not without assigning any reason. What is this? SRP will say anything that he wants.
At the time of
There's arbitrary powers.
No, at the time of death, she was 27 years, 11 months, 20 days.
Nothing is there in the order. You can't supply something which is not there in the order. There's nothing in the order. If you would have given her, she would have seen whether you are correct or you are wrong. You can be wrong also. Because your SRP, whatever you say will be correct.
He is communicating the order on the basis of the decisions taken by the committee.
That we are understanding. But she is entitled to know the reasons. Only when she is given the reason, she will assail it. You may be wrong. You may be right. If you don't communicate the reason, how she will assail it? And how the court will see whether you are wrong.
Allow me to file an affidavit to communicating the decision.
After traveling 2013, your lordship closed the Supreme Court judgment.
This is order of 23.
Yes. The passage of time, 2013, the Supreme Court says, the compass.
Now, at present age,
no, sorry, I'm
constable is recruited up to that maximum 27 years.
Why don't you communicate the reason?
But there is a rule. There's a notification public. Malad is correct.
Which rule is this referring to? Show which rule it is referring.
Malad, no, when
Show which rule it is referring to, sir.
he has not mentioned that.
Nothing. What does he think? He can write anything to anyone.
No, sir.
Then he has to mention.
But decision of the.
She is exercising her right
Yeah.
under a scheme framed by your government. You are a functionary of the government.
Yeah.
When you are considering it, you are obliged to give the reasons for consideration.
To assent the order. We will communicate.
You communicate. This is unsustainable. You file affidavit in opposition. The petitioners.
Item number 20.
I am for the.
My lord, my lordly senior
Lord,
for the state manual, please indicating phone number 35. My
All right, let him come. Yes.
Yes, my lord, impugned order, last but one page to your lordship. Issue is whether the petitioner, husband of the petitioner, was working in the temporary post of the government sanctioned post shall be counted for the purpose of getting pensionary benefit. This
How
issue
long he worked as a on a
my
temporary
lord, appointment since 1981 till 1997 casual.
Thereafter, he was made permanent.
Permanent. Retirement date, my lord, 31st August 2004. The government authorities, that is my employer, already endorsed.
So 7 years. He has worked for 7
Yes.
years as a
Permanent. And my lord, the government authorities, that is my employer, endorsed that since those appointments were made, keeping in mind we are all casual worker, our age bar should be condoned. That is the finding from their end itself.
Age relaxation is there is a decision of the government
Yes,
covering that field.
covering that field, and that point was taken by earlier authorities.
That notification or decision of the government, does it say anything how the service rendered as a casual is to be treated.
No, that has been interpreted by Honorable Division Bench, upheld by the Honorable Supreme Court. And that, yes, straight away. Obliged to your Lordship. I have annexed. Page 89. I am obliged to your Lordship getting it matter the short. And that has been cited before the tribunal itself with a written notes. Well, written notes has been bypassed on the basis of submission. It has been even their rejoinder, they have admitted the fact. But kindly read, I am not reading. 2014 3 CHN. Interpreted all these sections, rules.
You have seen this. What is the shortfall?
But shortfall in the sense of 7 years something.
No.
Yeah, 3 years something.
3 years.
Yes. But taking into consideration of our casual work for long time, pensionary benefit should be given notionally for the purpose of only pension. This plea was taken paragraph 7 onwards, internal page 92. What was the contention of the state? That has been diluted. Similar set of facts. Judgmental compilation today. আমার জাজমেন্টটা কোথায়? No. আচ্ছা। দুটো দিয়ে দে। কপি লাগবি? এটা একটু কাইন্ডলি দে দেন।
We have considered this judgment.
Detailed and in view of this Supreme Court next page, my lord, Supreme Court kindly sees page.
We have considered this.
Already, my lord, I have made a compilation for your lordship, series of judgment, including your lordship judgments.
That is why I am remembering. Considered this.
Yes, and that too in the rejoinder. Kindly come to their rejoinder. They have admitted. Page 57. Page 58. They have admitted our claim. An authority already, my lord, said it is to be condoned. Page 39. Page 58, then come to page 39. This is the government's order for condoning our such age bar. First paragraph, last line. Hereby condone. And that too, retirement 2004.
Because the rule says initial entry.
Entry, not for the permanency. Because I am the employee of that particular, even casually. And my lord, one thing, 2004 retirement. During the pendency of the tribunal application, the petition, husband of the petitioner expired, that is original employee. Substitution made. I am the widow of that particular employee, arrear up to 2020 from the date of retirement
and pension
and family pension and all other retirement. I'm leaving to lordship. The series of judgments I have quoted with paragraphs. I leave it to lordship. কি বলবে এটাতে?
My instruction.
Yes.
Your Lordship, I have been handed over a bunch of instructions which says Office of the AG, which says that the service tenure was not complete. 7 years service was there. So that is why whatever the SAT has said in its order, Your Lordship.
In that case, also a similar ground was taken, if I remember correctly. The AG has raised the objection.
Yes, in that judgment itself, paragraph 7 onwards. Same plea was taken. He did not complete the 10 years as per Rule 36. Recurrence is going on.
Those instructions were placed before the tribunal.
Yes, we had filed our affidavit,
So there is
rejoinder and reply
There is
was
nothing new that you want to place on record.
maybe not.
Then you go through the judgments, we'll hear you.
Yes, everything is there since 2014.
Give her a copy.
A copy compile.
If they are all reported, at least give her the citation.
All I am giving a bunch. Kindly consider all these judgments so that in future we can get it through. But searching of all these difficult. But in your lordship judgment, if it is quoted, then we can get it very easily. That is why I made it compilation. Your lordship judgment, my Justice Tapapada Chakraborty's judgment, my Justice Pranab Chattopadhyay's judgment.
My lord, in this I am appearing for response 3, my lord, Office of the Accountant General, my lord. My lord, we are under obligation to observe this unless the employer of the employee condones the delay and sends the requisite sanction to our office, my lord. We are under obligation to observe this. They are the shortfall.
You are not aware of the rules.
Rules, but that has to be accordingly sanctioned by the pension sanctioning authority, my lord. That is the difficulty.
That we know that only after sanction the PPO can be issued.
Absolutely, my lord.
But when you raise an objection, should you not raise an objection keeping in view the rules? When you know that the rule provides that notionally it is to be counted, then why do you say not entitled? You should say that please send the sanction in accordance with these rules or a decision in accordance with these rules. At least you should quote the rules.
My lord, absolutely, my lord. It is always within the domain of the employer to sanction the same. My
Not
lord,
a question of sanctioning, it is their rule. Their rule itself says that the date of initial entry, whether in substantially or otherwise, something like that.
Like that, and Honorable Supreme Court, my lord, already dealt with the issue of already Supreme Court decision is there. So, my lord, therefore, it is very difficult. 20 years passed. My lord, kindly see, I was astonished and my lord, getting excited. Why this type of people will not get the benefit after 20 years and ply it from pillar to post, and she will die also in the meantime.
The Petitioners' Council has handed over a compilation of decisions which it proposes to rely upon. It is submitted by the State Council.
Otherwise, my lord, kindly release the matter.
Affidavit of service.
My lord, she has been, my lord, released, my lord. Kindly release the matter, my lord.
Kudi,
Kindly
20.
release Act number 147. So that I can try my luck somebody from my left, my lord. Tomorrow is the last day, my lord, before joining the new full-fledged posting. In Guwahati, my lord. My lord, she has already done a very hard posting in Jammu, my lord. And with, my lord, before the cooling period, she sought to be transferred to Guwahati, my lord. Grateful.
Grateful. Much obliged to you.
A affidavit of service.